our dear chairman, the people's chairman, the chairman who has given us perhaps our most enjoyable long week ever, the evidence, bold, and understood, Thank you very much, sir. I will also have here former chairman, Pals Oyo Esquire, the bulldozer, and of course the treasurer of the bar, Mrs. Joyce Obasi. Very to have you. This law is one that has brought about a lot of innovations in technology and other aspects, and this is attributable to the innovations of the chairman of the law, Sam Atoy, Spirit of Agriculture. Thank you very much. Without much ado, we shall be going straight to the event, and it is time for us to make our introductions of the resource persons that will handle the issues in today's event. It's a very, very germane topic, the role of courts in enforcement of arbitration clauses and agreements in arbitration. Okay. I'm just been told by my team that we'll have more introductions to make. Executives of the Nigerian Institute of Arbitration here present, His Worship, retired magistrate UIEOR. Pleasure to have you here. Your noble worship, retired magistrate special grade, Samuel Musigbe, alternate. You're welcome, sir. Samuel Erobosa, Secretary of the Nigerian Institute of Arbitration. Pleasure to have you here. The former Secretary of the Bar, Ayo Edeki. It's a pleasure to have you here, sir. Just put your hands together for me. A very senior member of the bar, Godfrey Arami Esquire. Pleasure to have you here, sir. We also have here Martina Otoy Esquire, active barman, chairman of the Law 2024 law. Emmanuel Kosu, former publicity secretary. This is the man that handed over to me as public secretary. Where are you? Always looking for a interest. Thank you for having me. So we're going to be introducing the resource persons. And before doing that, we're going to read their resume. And to do this is the publicity secretary of the bar, the very Benin, Mr. Joshua.
Thank you so much, Mr. Douglas. I'll invite one of the compare. We are not alone. Mr. Theophilus Moro, I beg your pardon, Miss Ogenetega Eswako. She's one of the compares and she'll be reading citations with me. But alongside the people hosting this morning's session is Mr. Theophilus Moro. Please a round of applause for the team. So very quickly, we will be constituting the panel for this morning discussions on the ADR topic. And the chairman of the panel is no other person than my Lord Honorable Justice B.O.A. Obiawe. And I will briefly read my Lord's citations now. My Lord's citation. Our distinguished guest is a Honorable Justice of the High Court of Edo State, where he serves on the Civil Division of the High Court in Benin City. He is a member of the Edo State Judiciary and participates in the adjudication of civil disputes, interpretation of statutory provisions, and delivery of judicial decisions within the State High Court system. After a meritorious service at the Ministry of Justice, Edo State, where he rose to the ranks of the Director of Public Prosecutions, he was appointed to the Edo State High Court bench, where he currently sits at the High Court's 9 Benin Judicial Division. In his capacity, he contributes to the administration of justice through the hearing and determination of civil matters in accordance with the Constitution and applicable laws of Edo State. He is a serving judicial officer within the Edo State Judiciary, committed to the dispensation of justice. Please make welcome our distinguished guest, Honorable Justice Victor My colleague will read the citation for the lead speaker. Melody is the chairman of today's session. Melody, all concerned.
Dear colleagues, you're welcome once again to the Law Week 2026. My Lord Justice T.I. Abe is one of our guests and keynote speaker for this session. Our distinguished guest is a judge of the High Court of Edo State, serving within the Benin Judicial Division of the State Judiciary. Her Lordship has contributed to the administration of justice through the adjudication of civil and family matters, supporting the development of equitable and efficient dispute resolution within the Edo State judicial system. As a member of the State High Court bench, she forms part of the judicial cadre responsible for strengthening access to justice and upholding the rule of law in Edo State. Her service reflects dedication to judicial duty, procedural fairness, and the integrity of court system. It is also worthy of note that our guest, Honorable Justice T.I. Abe, was a one-time vice chairman of the NBA Benin branch. We are honored to welcome Honorable Justice Teresa Abe. Welcome.
While my Lord's citation was being read, we just had the privilege of being graced by another very learned jurist. It is my most singular honor to recognize the presence of my Lord. We know him as the digital judge. We are the some of us call ourselves some of us. My Lord, the Honorable Justice A.I. Our next panelist is someone of no mean repute. Our next panelist is someone of no mean repute. Mrs. Ruth Waimure. Member of the Nigerian Institute of Chartered Arbitrators. Our distinguished guest is a legal practitioner and an alternative dispute resolution specialist. She has experience in litigation, arbitration, mediation practice within public and institutional legal frameworks of this great state of ours. And like I said earlier, she's a member of the Nigerian Institute of Chartered Arbitrators, and she's an active participant in professional arbitration and mediation, in the development of professional arbitration and mediation in Nigeria. She serves as State Counsel in the Edo State Ministry of Justice here in Benin City, where she is involved in legal, advisory services, and public sector litigation. She's also a member of the Edo State Multi-Door Courthouse Panel of Neutrals, where she so meaningfully contributes to the resolution of disputes through mediation mediation and other alternative dispute resolution mechanisms. She is widely engaged in professional development programs, workshops, and training activities within the arbitration and mediation community in Nigeria. We are most honored to welcome Mrs. Ruth Owalimere.
While the citations for Mrs. Ruth Owalimere was being read, our attention was drawn to the presence of the immediate past chairman of NICA, member of the panel to discuss the paper of the lead speaker is our own, but we know he has crisscrossed several areas of arbitration. And I'll quickly be reading the profile of Mr. Olifo E. Thomas. Our distinguished guest is a legal practitioner and public sector professional with specialization in governance, administration, and alternative dispute resolution. He is a member of the Nigerian Institute of Chartered Arbitrators, reflecting his professional engagement in structured arbitration and meets reflecting his professional engagement in structured arbitration and mediation practice within Nigeria's dispute resolution framework. He has served in public sector administration and coordination capacities within Edo State, contributing to governance support structures and institutional processes connected to legal and administrative development. His professional involvement involves participation in arbitration-related frameworks and public sector governance coordination. He is recognized for his contributions to administrative governance support and alternative dispute resolution practice within Edo State's legal and institutional environment. We are honored to welcome Mr. Olifo E. Thomas, FCA.
Thank you very much, sir. To God's prime homage for that beautiful session. I love the chairman of the session. I love the people that will look forward to this profession from the days of the PPP of the states. We have a very interesting topic in that, which is the role of courts in the enforcement of arbitration clauses and agreements on arbitration. While preparing for this session, I came across the definition of alternative dispute resolution from Focus.com. Says, ADR is shifting focus from winning arguments to understanding people, preserving relationships, and finding constructive solutions. So, with that very apt aphorism, I want my Lord to keep the ball rolling. Thank you, my Lord.
Thank you very much for completing this morning's session. May I firstly particularly appreciate my Lord Honorable Justice Dr. Pauli of the Federal High Court, the Federal Society. He said to me yesterday, my Lord, viewing as what he calls me, tomorrow morning, ensuring the paper, of course, I've been attending, then I'm with the point of duty to be here this morning at this session. And then at 5 minutes to 9, he was already here. Of course, we are not convened, not even converged. And so we had to retreat to his chambers. And then before we now came together. I Lord, appreciate you for me. I appreciate your commitment to the bar, which you demonstrated. Of course, you chaired this session yesterday, and I was here. This is not quick or Thank you, my love. And then I appreciate also my boss here present to be in on this session this morning. I welcome us all here today. Now we have this topic, the role of courts in the enforcement of arbitration clauses and agreements in arbitration in Nigeria. There's no doubt that the arbitration is becoming, if you like, a growing practice in our country. And against the background of the theme of this conference, which is reforming today, securing tomorrow, it's only fitting that we can should devote this session, as we are doing our currently, to discuss arbitration. For this is, in my respectful view, one of the ways to go. The courts are clustered. I think gone should be the day where every dispute, no matter its nature, ends up in the litigation law. With the courts having to, shall I say, chew more than they can swallow. So arbitration, or the practice of ADL, is what we must all embrace. And this will be a veritable a way around the conjecture in our courts, outside of course of the benefits of arbitration, mediation, other ADR processes. But this morning the focus is on arbitration. And then we have my Lord himself, my Lord his guest, very qualified to talk to us on this issue this morning. My Lord, the Honorable Justice Teresa Irene is a fellow of the Chartered Institute of Arbitrators. She's also a fellow of the Institute of Chartered Mediators and Conciliators. So you see, she belongs to several fellowships. And this morning, I'm sure that she will not just regale us, she will provoke our thoughts, she will deepen our understanding of ADR, particularly the emphasis on arbitration, such that where they have lived, and perhaps also bring a perspective, right, to the issue under discussion. Of course, Mr. Olifo, has a passion, I know this, for ADR, amply qualified to talk to us also as he discusses the paper also, and perhaps offers us the benefit of his own perspective on the issue. So without much ado, to be my honor to invite my Lord, the Honorable Justice Teresa Irene of the Edo State High Court to deliver her paper, my Lord.
My Lord, Chairman of the session, the Honorable Justice V.O.A. Oviawe, my noble lords here present, learned senior advocate of Nigeria here present, the chairman of the MBA Benin branch, permit me to stand on the existing protocol already read out by the convener of session. It is an honor and a privilege be here today to deliver a paper on a topic that is as important as this in present-day Nigeria. On that note, I wish to thank the chairman of the MBA Benin branch, Idemide Eredia Osifo, Chairman Planning Committee of the Law 2026, Samuel Matoi, and the Chairman of NICA, Edo State, Retired Magistrate UI Iowa. I wish to also commend the bar for inserting a time, a day, a special period for conversation on ADI. I believe the MBA Benin branch, they are trailblazers and they deserve a round of applause. The role of courts in the enforcement of arbitration clauses and agreements in arbitration in Nigeria. Arbitration has become one of the most significant mechanisms for dispute resolution in modern commercial jurisprudence. In an era where commerce transcends territorial boundaries and parties increasingly seek speedy, confidential, flexible, and technically specialized mechanisms for resolving disputes, arbitration has emerged as an indispensable alternative to litigation. The growing complexity of commercial transactions, foreign investments, maritime activities, construction contracts, oil and gas operations, telecommunications, banking, and international trade has further increased reliance on arbitration as an efficient dispute resolution mechanism. Parties are often attracted to arbitration because of its procedural flexibility, party autonomy, privacy, neutrality, and relative speed when compared with conventional litigation. However, arbitration cannot thrive without judicial support. Although arbitration is founded on the principle of party autonomy, courts remain indispensable to its legitimacy, effectiveness, and enforceability. The relationship between courts and arbitration has therefore evolved globally from one of suspicion and hostility to one of cooperation, supervision, and support. Nigerian legal system recognizes arbitration as a valid and enforceable means of dispute resolution. The enactment of the Arbitration and Mediation Act, AMA 2023, represents a transformative development in Nigeria's arbitration jurisprudence by aligning Nigerian arbitration law with international best practices and the ancestral modern law. The role of courts in enforcing arbitration clauses and agreements is therefore pivotal. Nigerian courts are frequently called upon to recognize and uphold arbitration agreements, state proceedings commenced in breach of arbitration clauses, compel parties to arbitrate, appoint arbitrators where parties fail to do so, grant interim protective measures, recognize and enforce arbitral awards, and protect the integrity of the arbitral process.
My Lord, I'm sorry. I apologize for interjecting at this stage. I thought that before we are too far gone and we should set the ground rules. You have 30 minutes to deliver the paper. Thank you very much.
This paper examines the legal framework governing arbitration agreements in Nigeria, the powers and responsibilities of courts in enforcing such agreements, judicial attitude towards arbitration, relevant case law, challenges to confronting enforcement and recommendations for strengthening arbitral practice in Nigeria, conceptual clarifications, the meaning of arbitration. Arbitration is a private dispute resolution process whereby parties voluntarily submit their dispute to an arbitral and impartial tribunal whose decision is binding on them. Section 9 of the Arbitration and Mediation Act 2023 defines an arbitration agreement as, quote, an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. End of quotation. Arbitration is fundamentally contractual in nature. The jurisdiction of the arbitral tribunal is derived entirely from the consent of the parties as expressed in the arbitration agreement. The principle of party autonomy remains the cornerstone of arbitration. Parties are generally free to determine the governing law, seat of arbitration, language, number of arbitrators, procedural rules, and institutional framework applicable to their disputes. An arbitration clause is a provision inserted into a contract requiring disputes arising from that contract to be referred to arbitration. An arbitration agreement is a broader legal concept. It is an agreement by parties that disputes between them will be referred to arbitration rather than being determined by a court through litigation. An arbitration agreement may also exist as a separate agreement entered into after disputes have arisen. The Supreme Court in the case of Meguya and Imokwede, they affirmed the sanctity of arbitration agreements and the principle of party autonomy when it held that parties who freely enter into arbitration agreements are bound by those agreements. The Apex Court went a step further, establishing that courts must actively salvage defectively drafted clauses, such as a mistaken reference to a non-existent institution, rather than use technicalities to strike them down. If the intent to arbitrate is clear, the court's job is to enforce it, simple and straightforward. The decision underscores the broader principle that courts must respect lawful contractual agreements voluntarily entered into by parties. See also the case of Mekuye against Lotus Capital Limited. The binding effect of arbitration agreements flows from the broader doctrine of sanctity of contracts. Once parties agree to submit disputes to arbitration, neither party should ordinarily be permitted to rescind from that agreement, merely because litigation subsequently appears more advantageous. The principle of non-hostile jurisdiction. It is a foundational principle of Nigerian jurisprudence that the existence of an arbitration agreement does not operate to completely divest or oust the court of its constitutionally defined jurisdiction. Due to the fact that judicial jurisdiction is fundamentally conferred by the Constitution and enabling status, parties therefore lack the legal capacity to strip a court of its inherent powers via a private contract. The locus classicus on this principle is the Land Bank Supreme Court decision of Bembe and Memorable Estates, where under Fatai William JS decisively established and stated of quote, any agreement to submit a dispute to arbitration such as the one referred to above does not oust the district jurisdiction of the court. End of quote. This enduring position has been consistently maintained by the Apex Court, as re-emphasized in Sakamori Construction Nigeria Limited and Lagos State Water Corporation, and reaffirmed in UBA PLC and Trident Consulting Limited, where the Supreme Court also held, quote, where parties opt to arbitrate over disputes, it does not automatically oust the jurisdiction bestowed on the court by the 1999 Constitution. Thus, an arbitration agreement cannot and does not completely oust the jurisdiction of the court. End of quote. An arbitration clause does not act as an automatic jurisdictional bar. Rather, it creates a contractually agreed condition precedent to litigation. It effectively serves to temporarily postpone a party's right to immediate judicial recourse, placing the activation of the court's active adjudicatory powers into a state of conditional abeyance until the private arbitral mechanism has been exhausted. Therefore, when a lawsuit is filed in blatant breach of an arbitration clause, the proper procedural remedy for a defendant is not to seek a dismissal for lack of jurisdiction, but to tenuously invoke the provision of Section 5 of the AMA 2023 to request a stay of proceedings. Under Section 5.1, the court is mandated to refer the parties to arbitration if a valid agreement exists. Crucially, Section 5.2 permits the arbitral proceedings to continue and an award to be made while the court matter is pending, while Section 5.3 empowers the court to issue vital interim or supplementary orders as may be necessary. By granting a stay rather than a dismissal, the court strategically defends its active adjudication while firmly retaining its ultimate supervisory jurisdiction. The legal framework for the enforcement of arbitration agreements in Nigeria. One is the Constitution of the Federal Republic of Nigeria, 1999 as amended, where Section 6 of the Constitution vests judicial powers in the court. Although arbitration is a private dispute resolution mechanism, courts retain supervisory jurisdiction over arbitral proceedings and awards. This constitutional rule is not to usurp arbitral functions, but to ensure that arbitral proceedings comply with the law, principles of fairness and public policy. Also of reference, award to be reviewed by an award review tribunal before eventually proceeding to court. There's also the National Policy on Arbitration 2024 to 2028, the New York Convention 1958, United Nations Convention on International Settlement of Arbitration Proceedings can only be and must be exercised in accordance with the provisions of arbitration proceedings, can only be and must be exercised in accordance with the provisions of Section 5 of the arbitration law. Failure to exercise the power and provisions of Section 5 of the arbitration law. Failure to exercise the power in accordance with the provisions of the law renders the decision or order a nullity. The courts have consistently recognized that permitting litigation in the face of valid arbitration agreements undermines party autonomy and defeats the essence of commercial expectations of contracting parties. 2. Compelling parties to arbitrate. Where one party refuses to arbitrate despite an existing arbitration agreement, courts may indirectly compel compliance through stay In NNPC against Computer Engineering Code, the Supreme Court recognized the obligation of courts to give effect to valid arbitration agreements. Also see Chartering and Shipping Limited. See also the case of owners of MV against Lopez, Nigerian Overseas Chartering and Shipping Limited. This recent pronouncement of the Apex Court reaffirms the principle of sanctity of contract within the arbitral context. It establishes that a court's inherent suitability to try a matter cannot be used to unilaterally override the explicit voluntary choice of the parties. By ensuring that valid arbitration clauses are given full operational effect. This decision provides vital commercial predictability, confirming that clear contractual commitments to arbitrate will be consistently respected and supported by the judiciary. Appointment of arbitrators. Courts play an important supporting role where parties fail to appoint arbitrators in accordance with agreed procedures. Under Section 7.4 of the Arbitration Regulation Act 2023, where parties or arbitral institutions fail in appointment procedures, the court may appoint arbitrators to prevent the frustration of the arbitral process. This power is particularly important in situations where one party deliberately refuses to cooperate in constituting the arbitral tribunal in an attempt to frustrate proceedings. In Beola and Sani, the Court of Appeal confirmed that where a party fails or refuses to participate in appointing an arbitrator after due notice, the court has a clear statutory power to step in and make the appointment. Ultimately, this judicial power to appoint arbitrators ensures continuity, preserves the efficacy of arbitration agreements, and prevents an outright abuse of process. Grant of interim measures. Courts play a pivotal role presenting the subject matter of the dispute before ordinary arbitral proceedings. Under Section 19 of AMA, the court has the explicit power to issue interim measures of protection. This supporting jurisdiction is critical because arbitral tribunals may lack immediate coercive apparatus of the state required for urgent enforcement against non-compliant parties. Interim judicial intervention is not inconsistent with arbitration. Rather, it strengthens the arbitral process by maintaining the status quo and preventing the party from dissipating assets or destroying evidence before the tribunal can deliver its final determination. Enforcement of arbitral awards. The ultimate strength of arbitration lies in the enforceability of arbitral awards. Courts enforce arbitral awards in substantially the same manner as judgments of the courts. In EcoBank against Admira Environment Care Limited and others, the Court of Appeal reiterated that arbitral awards are binding and enforceable unless valid statutory grounds exist for refusing enforcement or setting the awards aside. The courts have repeatedly emphasized that arbitral awards should not be lightly interfered with because parties voluntarily chose arbitration as their dispute resolution mechanism. Recognition and enforcement of arbitral awards remain essential to maintaining confidence in arbitration as a viable commercial dispute resolution mechanism. Setting aside arbitral awards. Although courts generally support arbitral awards, they retain narrow supervisory powers to set them aside on the strict statutory grounds listed under Section 55(3) of the AMA 2023. These exclusive grounds include legal capacity of the party, composition of arbitral tribunal, and invalid arbitration agreement, lack of proper notice, tribunal exceeding its scope, procedural irregularities, non-arbitrability, or conflict with public policy. Importantly, courts do not sit as appellate tribunals over arbitral decisions. In Dantata and Ceylon Multipurpose Cooperative Society, the court clearly defined this boundary when it held to us, quote, "It is imperative to state at this onset that the court consider an application for the enforcement of an arbitral award or the setting aside of the arbitral award does not sit on appeal over the decision of the arbitrators. After all, it is humble that law that parties take the arbitrators for better or for worse, both as of the decision of the fact and the decision of the law. They cannot, when the award is good on the face of it, object to the award on grounds of law or facts. Since the lower court, in considering the application for the enforcement of the arbitral award, is not sitting on appeal over the decision of the arbitral tribunal. Once it is satisfied that the arbitral tribunal complied with the law as the arbitral tribunal understood it, rightly or wrongly, as they perceive it, that ends the matter. As parties take the arbitrators as they find them, for good, for bad, for better, for worse. It is like a marriage relationship. This decision reinforces the principle of finality in arbitration, confirming that a court cannot unpack the substantive merits or retry the case simply due to a party dissatisfaction with the outcome. Now that my Lord has told me the time I have, I know it's a stickler for it. I think for an extension of time, my Lord. It's a 10-paragraph affidavit. Thank you, my Lord. I'm very grateful, my Lord. Historically, Nigerian courts were at times perceived as interventionist in arbitration matters. However, contemporary judicial attitudes have become increasingly arbitration-friendly. Modern Nigerian courts now structurally integrate the arbitral process not as alternative adjudicators, but as supportive stabilizers designed to lend their power to the process when it requires formal legal backing. In Mekuya and Inogo de Supra, the Supreme Court reaffirmed party autonomy and judicial support for arbitration by emphasizing that parties who willingly agree to arbitration must honorably be bound by that agreement. Also, in the owners of MV Lopez case, the Apex Court made it clear that courts are bound to respect arbitration agreements and state their own proceedings unless there is an overwhelming reason not to. The prevailing judicial philosophy is therefore that courts should support rather than obstruct arbitration. Under this framework, judiciary acts in a strictly supportive curatorial capacity with intervention limited to specific statutory touch points under the Arbitration Regulation Act 2023. A primary expression of this supportive role is found in the court's independent power to grant urgent interim relief under Section 19 of the Act, which mandates the court to deliver a ruling within 15 days of any application. Complementing this is the court's role under Section 28, which mandates that an interim measure issued by the arbitral tribunal is binding and shall be enforced by the court. Furthermore, Section 34 protects the ultimate utility of the final award by completely excluding the time elapsed during active arbitration from statutory limitation calculations, ensuring the final award does not become time-bound before formal enforcement can occur. This pro-arbitration posture is not just an arbitral philosophy. It is not just an abstract philosophy. It has been practically institutionalized through the civil procedure rules of key jurisdictions to defeat tactical litigation delays. Locally, this pro-ADR attitude is provided for under Section 26 of our own rules, the State High Court Civil Procedure Rules 2018, which explicitly empowers the court to promote amicable settlement or the adoption of alternative dispute resolution. The rules also embed the State Multi-Law Courthouse directly into formal judicial stream, thus establishing a dedicated institutional framework for legal practitioners in the state to resolve disputes outside the traditional courtroom system. Crucially, this statutory framework provides strict mechanisms to deter bad faith litigants from utilizing ADR as a stalling tactic, while simultaneously establishing a robust framework for post-award enforcement. Under Rule 3, the court enforces strict timelines for parties to file statements once a matter is referred, penalizing non-compliance with severe consequences under Rules 3.5, such as a dismissal of the suit or a default judgment where appropriate. However, Rule 3.6 provides that judgments given under Rule 3.5 above may be set aside upon an application made within 7 days of the judgment or as the court may allow. Notably, Rule 11H states that an award filed in court will have the same force and effect as a judgment. This streamlined domestic approach is matched by an equally progressive global outlook under Rule 14, which provides for the registration and enforcement of foreign arbitral awards via the Foreign Judgment Reciprocal Enforcement Act. Furthermore, by empowering the Chief Judge under Rule 11.1 to designate a dedicated arbitration judge, tax primarily with the remission and enforcement of arbitral awards, the Edo State rules therefore thus provide a potent blueprint for promoting ADR in Nigeria. Similarly, Order 28 Rules 1 and 2 of the High Court of Lagos State Civil Procedure Rules 2019, once pleadings are closed, cases deemed suitable, are systematically referred to the Lagos State Multi-Law Courthouse, LMDC, or designated ADR judges for targeted judicial support. Rule 3 thereof mandates that applications to appoint or remove arbitrators, state court proceedings, or subpoena witnesses must be brought via an originating motion or notice. Rule 4 ensures finality by allowing arbitral and LMDC awards to be enforced in the same manner as a judgment of the court, while strictly capping initiated. Furthermore, Rules 9 and 11 empowers the Chief Judge to formally designate specialized ADR judges, establish a dedicated SIFTA committee to actively identify cases that may be resolved. To ensure strict compliance, case management timelines are clearly stipulated across these jurisdictions. Order 26 Rule 3.1 of those state rules mandates that claimants must file a statement of claim within 7 days of the referral order and defendants reply within 7 days of service. This case management timeline is structured at 14 days for both parties under Order 28 Rule 2.3 of the Lagos State Rule or the Lagos Rules and Order 24 Rule 4.1 of the FCT rules. Additionally, these rules back judicial directives with explicit financial procedural sanctions. Order 26 Rule 3.3 of the Lagos State Rules, a failure to file a timely notice of compliance within 14 days attracts a daily fine of 200 naira. This sanction is also mirrored by Order 28 Rule 4.3 of the FCT rules, which penalizes the failure to file a notice of compliance within 20 days. Furthermore, Order 28 Rule 3.3 of the FCT rules empowers courts to impose a penalty if a party refuses to submit to ADR and subsequently loses the substantive case in court. Ultimately, the evolved judicial attitude and these accompanying rules ensure that party autonomy is protected without making the process vulnerable to non-compliance. This arbitration-friendly posture has become increasingly important in attracting foreign investment and positioning Nigeria as a dependable regional dispute resolution hub. Limits of court intervention. Principle of minimum judicial intervention is central to modern arbitration practice, serving as a constitutional boundary that prevents the judiciary from overshadowing private tribunals. Excessive judicial interference inherently defeats the advantages that drive the adoption of ADR, namely speed, flexibility, efficiency, confidentiality, and absolute party autonomy. When courts routinely interrupt arbitral process at an early stage, they inadvertently transform the speeding mechanism into a prolonged and costly application of traditional litigation. Reflecting this boundary, Section 64 of Act 2023 stipulates the non-intervention principle by mandating that no court shall intervene in any matter governed by the Act, except where expressly provided by the Act itself. This provision is designed to curtail judicial overreach. A critical facet of this implement intervention framework is knowing exactly when a court must step back to let the arbitral process function. When a commercial dispute arises, a party seeking to avoid arbitration will frequently approach the court to argue that the arbitral tribunal lacks the right to hear the case, often for the alleged lack of jurisdiction. In handling such complicated applications, the role of the court is fundamentally guided by the doctrine of competence, which is explicitly provided for Section 14 of Act 2023. This principle mandates that the arbitral tribunal possesses the primary duty to rule on its own jurisdiction, including any objections regarding the existence, scope, or validity of the underlying arbitration agreement. The immediate implication for the judiciary is that a court must decline to resolve this jurisdictional dispute at a premature stage. If a party files a lawsuit or seeks an injunction to halt an ongoing arbitration based on a jurisdictional objection, the court's proper role is not to delve into the merits of that objection, but to refer the parties back to the tribunal. The law explicitly structures this order of operations to ensure the arbitral process is not paralyzed by any litigation. Under Section 14(6) and 7 of Act 2023, even if a dissatisfied party exercises their right to challenge the tribunal's plenary jurisdictional ruling in the court, that application before the court does not act as an automatic stay. Tribunals are statutorily empowered to continue with the proceedings and make an award, notwithstanding that a party has recourse to court in respect of such ruling. This principle has been upheld by the Court of Appeal in the case of Candy Johnson and others against AP and others. Therefore, courts must maintain this balance between providing necessary judicial support at authorized stages and avoiding excessive obstruction during the life cycle of the dispute. The judiciary's supervision power is not eliminated. Rather, it is properly deferred to the tail end of the process, thus allowing the court to review issues raised holistically during the enforcement or setting aside stage under Section 55 of Act 2023, rather than interrupting the arbitration before it can even get underway. Public policy recognition and enforcement of awards. An arbitral award is a final and binding instrument under Section 57 of Act 2023. Once an award is rendered by a tribunal, it shall, upon a formal application writing to the court, applications to completely set aside the award under Section 55, AMA 2023, or refuse its enforcement under Section 58, AMA. When navigating this final stage, courts must firmly reinforce a foundational tenet of commercial dispute resolution, which is that an enforcement court does not sit as an appellate court over an arbitral panel. The statutory windows provided for judicial review are strictly supervisory and not appellate. Once a court is satisfied that the tribunal complies with the law, that ends the matter. See the case of that Senior Multipurpose Cooperative Society Limited, SOCRA. Flowing from this, an alleged error of law or fact appearing on the face of the award does not grant a court the license to retry the case or re-evaluate the evidence. In fact, Section 55(2) explicitly blocks this by stating that an application for setting aside an arbitral award shall not be made on the ground of an error on the face of the award or on any other ground except those expressly stated under Section 55(3). Both Section 55(3) for setting aside and Section 58(2) for refusing enforcement restrict the court's intervention to a specific exhaustive list, which includes incapacity, improper notice, or a tribunal composition that fundamentally deviates from the parties' agreement. Outside of this party-proven grant, the court may only intervene so as contained on its own motion if it finds that the subject matter is not arbitrary or that the award itself is against public policy. In our jurisprudence, public policy is not a legal void, as our courts have not defined it as the principles under which the freedom of contract or private dealings is restricted by law for public good and is deeply rooted in the defense of legality, statutory compliance, and foundational justice. See the Supreme Court's decision on this in Okonkwo and Okagbo. The ongoing challenge, however, is the opportunistic expansion of the judicial definition by creating very creative litigators who attempt to recharacterize simple commercial disagreement or an arbitrator's alleged misinterpretation of a contract as public policy violations. They argue that an incorrect assessment of damages or an adverse interpretation of a clause is fundamentally against the public good simply due to their dissatisfaction with the outcome. The modern trend demands that the public policy exception should be interpreted with strict narrowness, triggering an intervention only if the enforcement of the award would flagrantly violate Nigeria's constitutional values, enforce an explicitly illegal contract, or shock the conscience of the courts. By maintaining this strict threshold across the entirety of Section 55 and 58, Nigerian courts fulfill their true role as supportive partners in the arbitral ecosystem, ensuring that the final doors of the court remain firmly closed to frivolous appeals, while remaining properly open only to rectify undeniable injustice. There are some challenges.
Upon your application, for time extension.
My Lord is granting a ruling, deliver a ruling. And the government. Some challenges, I'll just give some and just quickly around them. Challenges facing the enforcement arbitration agreement, judicial delays, excessive court intervention, poorly drafted arbitration clauses, public sector resistance, lack of specialized judicial training. As a comparative analysis there, where I compare some jurisdictions, Singapore and all that, I'll skip that. Recommendations. We need to curb abuse of process with personal cost sanctions, maximizing ADRO costs and adoption of settlement weeks, like we do in those states, operationalizing the awards review tribunal, improving drafting of arbitration clauses. Conclusion. The true role of the judiciary in the enforcement of arbitration clauses and agreements in Nigeria is fundamentally defined by an exercise of restraint and cooperation. Rather than diminishing constitutional authority, maintaining a highly disciplined, non-appellate threshold during enforcement and post-award phases represents a sophisticated exercise of judicial power in aid of justice. Commercial certainty and the economic development. When the bench actively protects the boundaries of the arbitral process under the framework of the Arbitration and Mediation Act, AMA 2023, the relationship between the courtroom and the tribunal transforms from one of competition to one of partnership. The Supreme Court perfectly reminded us in UPA PSA against Trident Consulting Supra that arbitration and litigation are not mutually exclusive. Indeed, the court often complements and supplements the functions and powers of the arbitrator. For example, by state of court proceedings in appropriate cases, justice, commercial certainty, and economic development. I thank you all very much for
requires us to lead you, my Lord. A huge round of applause. Thank you, my Lord. My Lord has once again put me on mentor. She has extensively, within the limits of the time available, which time she's so that's a he's so judiciously utilized. She has, I'm sure, enlightened us greatly on the subject. A wonderful presentation that she has made this morning. And to recap some highlights, she has talked about the indispensability of arbitration, our growing socio-economic view, that arbitration cannot thrive without judicial support, that point was strongly made, that arbitration clauses, she dwelt on the arbitration clauses and the binding nature of such clauses hinged, as it were, on the principle of sanctity of contracts. That arbitration agreements do not invest the costs of judicial made that point very clearly. They are not dwelt on the legal framework which are listed. And then she made a very strong point that the courts have consistently recognized that permitting litigation in the face of valid arbitration agreements undermines party autonomy and defeats the commercial expectation of contracting parties. She dwelt on enforceability, which is a great area. And then, of course, I'm sure that you will have this paper very enlightening, I can tell you. And she made the point that courts do not sit as appellate tribunals over arbitrary decisions. She drew our attention to the growing judicial support for arbitration and directed our attention to our rules of court. Not many of us are familiar with our rules, how the rules promote should be more given to embracing this practice. And then, of course, she, like I said, she worked on the enforcement of awards. She touched on the challenges facing enforcement arbitration agreements in Nigeria. And then, more importantly, she made recommendations. I don't can thank you enough for this very beautiful paper. If I had the powers, if we were not limited by time and the program that might follow, you can be sure I've given you 3 hours, not just to deliver but to expatiate on all these fine points. They are so eloquently delivered. Thank you very much. I'm sure the organizers will avail you a copy of this paper. It should be a practitioner's manual for area, make us appreciate the area more and perhaps encourage us in this line of practice.
And I would like to observe protocols already well established. Thank you very much. It is an honor and a privilege to be here this morning discussing.
I'm sorry, before you proceed further, I want to announce to the board, the House, that I hereby invest my Lord with the powers of the chairman for the next 5 minutes. Now you have 10 minutes to deliver.
Thank you. Go take Mr. Chairman. Thank you. My Lord delivered a very exhaustive paper on the rules of courts in the enforcement of arbitration clauses and agreements in Nigeria. He would have passed for a PhD seminar presentation. Thank you very much. Thank you, my Lord. So, my Lord went on to tell us what arbitration is as defined by Section 91 of the Arbitration and Mediation Act. So my question this morning is, what is the essence of arbitration? Arbitration, as we know it, is not merely a technical process. It's a philosophy of dispute resolution that emanated from the merchants when trade was being carried out across seas. Merchants came together to say they cannot, in Nigeria, we had customary arbitration long before our communities would resolve disputes through elders. In Benin, we have the Okaibe, we have the Otiowere at the community level. All those decisions have even been recognized by the Supreme Court as binding and constitutes exculpation, where the parties agree to be bound. I will quickly refer you to the cases of Agu and Ikewibe, 1991, 3 Nigerian Weekly Law Reports, Part 180, and Ohairi versus Akabeze, 1992, 2 Nigerian Weekly Reports, Part 221, where the validity of customary awards and recognizing and enforcing them was held as constituting exculpation by the Supreme Court. So what happened at the colonial and post-independence arbitration level? The Arbitration Ordinance of 1914 was largely molded after the English Arbitration Act of 1889. It introduced statutory arbitration as we know it today. That act was replaced by the Arbitration and Conciliation Act of 1988 that sought to modernize arbitration, and then it opened the door to judicial intervention, which had turned arbitration into a mere prelude to litigation. Like my Lord rightly said, we have creative litigators who came up with even various means to set aside an arbitration or to ensure an arbitration proceeding does not go on. So what then brought about this modern reform we're talking about? So Lagos, as always, is always in the forefront of development of laws. And Lagos State Arbitration Law of 2009 was what gave rise to institutions as the NICAP we are seeing today, and the multi-door courthouses that have now been adopted in most judiciary across Nigeria. And finally gave way to this landmark legislation my Lord dealt exhaustively with the Arbitration and Mediation Act 2023. So the role of courts, like my Lord said, is that of partnership and not rivalry with arbitration. She emphasized the decision of the court in Mekuye versus Mekuye, where the Supreme Court said that where parties have a valid or even slightly obscure clause to arbitrate in their agreement or in their contract, the court should ensure that they are made to abide by that clause. Because in Mekuye and Mokwele, what did we see? There was a reference to a non-existent arbitral institution, and they were trying to shoot down that arbitration clause. And the Supreme Court said no, they should be bound, they should go and explore arbitration. So courts have the duty, like I not like rightly said, in enforcing arbitration agreements, upholding the sanctity of contracts, and all the others she listed in her paper. But I would like to dwell on the transformative abolition of the error of law on the face of the award. It now became a doctrine in Nigeria. It was first brought about by the decision of the court in the Kano State Urban Development Board case, where the Court of Appeal held that an award would be set aside where an error of law appeared on its face. Thank God for the intervention of the Supreme Court that held that whether parties like it or not, like my marriage agreement, it is for better or for worse. Parties rise and fall on the choice of the arbitrators. It doesn't matter. And that is why these days in drafting agreements, arbitration clauses, people are careful to stipulate the expertise of the arbitrators. They now add it to agreements to say, oh, if a dispute arises, where the parties are to nominate or pick their arbitrators, the arbitrators must be well versed in construction, if it's construction agreements, or if it has to do with engineering matters, they stipulate at least one or two arbitrators, especially multi-party arbitration. If it has to do with marine issues, they also stipulate that arbitrators be well versed in those areas. So, the Court of Appeal also warned against the excessive reliance on this error on the face of the arbitration doctrine. This challenge was not unique to Nigeria. Internationally, courts have long grappled with the extent to which arbitral award should be subjected to judicial scrutiny. The celebrated case of Dala Real Estate and Tourism Company versus Ministry of Religious Affairs, Government of Pakistan, 2010 UK SC 46, and the subsequent decision of the Paris Court of Appeal in Dala Real Estate and Tourism Holding Company versus Government of Paris versus Government of Pakistan. The Paris Court of Appeal vividly illustrates the divergent approaches adopted by national courts when reviewing arbitral awards. Recognizing the dangers posed by excessive judicial intervention, the Nigerian legislature decisively addressed the matter in section 55, subsection 2 of the Arbitration and Mediation Award Act 2023. Sorry about that. It provides an application for setting aside an arbitral award shall not be made on the ground of an error of law on the face of the award or any other ground except those expressly stated in subsection 3. This provision represents a watershed in Nigerian arbitration law. It removes the judicially created doctrine of error of law on the face of the award and aligns Nigerian arbitration law more closely with international best practices embodied in the UNCITRAL Model Law and the New York Convention. Consequently, Nigerian courts are no longer permitted to undertake a merits review of arbitral awards under the guise of correcting legal errors. The result is greater finality, increased commercial certainty, reduced opportunities for dilatory litigation, and enhanced investor confidence in Nigeria as a seat of arbitration. So recent Supreme Court trends in arbitration jurisprudence. Although the Arbitration and Mediation Act 2023 represents the most significant legislative reform of arbitration in Nigeria since the enactment of the Arbitration and Conciliation Act 1998, it is important to acknowledge that many of the principles now codified in the Act are foreshadowed by the progressive jurisprudence of Nigerian appellate courts, particularly the Supreme Court. Over the last decades, Nigerian courts have increasingly embraced a pro-arbitration and pro-enforcement philosophy, consistent with international best practices. This judicial attitude reflects an appreciation of the fact that arbitration has become an indispensable mechanism for resolving complex commercial disputes in a globalized economy. A notable example is the decision of the Supreme Court in Mercury versus Mokwele, UPA, PLC versus Trident Consulting Limited, MV Lopez versus NOC. My Lord have dealt with all those ones exhaustively. And this evolution culminated in the enactment of section 55 sub 2 of the Arbitration and Mediation Act, which abolished error of law on the face of the award as a ground for setting aside an arbitral award. In many respects, the legislature may be seen as consolidating and strengthening a trend already emerging within modern Nigerian arbitration jurisprudence. The significance of these developments extend beyond dispute resolution. International investors, multinational corporations, financial institutions, and commercial actors frequently assess the reliability of a country's dispute resolution framework before committing capital. Like they say, the dollar is a coward. When you are putting your dollar in any economy, once there is litigation, they leave. Once there is any atom of litigation, that investment dies. Edo State experienced it earlier when ShopRite first tried to come into Edo State. As soon as there was a litigation in court, what happened? They left. They went to Delta. They went to other states. So the dollar is a coward. It doesn't countenance litigation of any kind. As Lord Steele famously observed, courts and arbitral tribunals are not rivals but partners in the administration of justice. The Arbitration and Mediation Act 2023 provides the framework for that partnership, while the Nigerian judiciary remains the institution responsible for ensuring that the framework achieves its intended objectives. So in closing, I would like to say, the enactment of the Arbitration and Mediation Act 2023 marks a defining moment in the evolution of commercial dispute resolution in Nigeria by strengthening the enforceability of arbitration agreements, introducing innovative mechanisms such as the Award Review Tribunal, recognizing third-party funding, and abolishing the disruptive doctrine of error of law on the face of the award. The Act firmly aligns Nigeria with contemporary international arbitration standards. The responsibility now rests with arbitrators, practitioners, creative litigators, let me borrow that term, and most importantly, the courts to give life to these reforms through consistent interpretation and application. If this is achieved, Nigeria will not merely participate in the global arbitration community, it will emerge as one of Africa's leading and most respected arbitracies. Thank you very much.
Thank you very much, Valerie. Thank you. We must thank you for time discipline. You limited your contribution to the time allotted. Thank you very much. Now we're having, I believe, a robust discussion on the topic. Before I call upon Mr. Olivo, very experienced, he's a neutral, and then he has a long experience and passion for India. May I just say this, that if he had the benefit of my Lord's paper well on time, I think that our emphasis should be on discussing firstly the paper and perhaps availing us of your perspective. My Lord is a scholar, talking about the speaker who presented the paper. And so, as scholar as she is, she actually will appreciate a scholarly discussion where the paper is perhaps complete. And then, for this purpose, there's no, I don't say that, I can't be here to say that's not how a discussion of this nature ought to go. But without preempting Mr. Olivo, may I now respectfully invite you to take the podium. Let's hear the views on the paper.
Lord, the chairman of the session, Lords, President Leonard Senior Advocate, Chairman of the Lion Bar, and Leonard Senior Distinguished Ladies and Gentlemen. I must say that I'm privileged and honored to be called upon to talk on this very elaborate paper that what the value of. It was extensive, and I must tell you, it covers the entire field of arbitration. Yes, I got the paper this morning, I quickly scanned through, but on delivery, I received on the debt and industry that was put into it to prepare the budget. I want to thank you for the question. My role here is to talk about some aspects of the paper. And what I've done simply was to look at issues relating to clauses and agreements in arbitration. And the issue has been that many of us who are lawyers, normally when situation arises, we tend to want to prefer litigation to arbitration for other legal processes. I mean, it is obvious, and we know why that is so. But I must say, as I was said by my fellow sponsor, that the trend is changing now, and there's a lot of improvement and appreciation of the need to ensure that alternative dispute resolution is encouraged and embraced. On that note, as I said, I'll be dealing with the issue of the arbitration process. You know, when clauses are inserted in contracts between parties in a particular transaction, mostly commercial nature, and they have done so that the party agreed to submit to resolve their dispute whenever dispute arises. That is the way focus. And as was said by the first discussant, actually the necessity for the use of arbitration and arbitration processes is because it provides very explicit party autonomy and the desire to ensure quick resolution of their dispute at less time and expenses. That is the reason. And I quite agree with that. Now, an arbitration clause or agreement is a legal provision in a contract where parties agree to receive future or existing, to resolve future or existing disputes through arbitration rather than filing a lawsuit in the court. By signing, parties agree generally to forfeit their right to file a civil lawsuit in the state of federal high court as it is in Nigeria. Now, clause or agreement is often used strategically, but there are slight differences in respect of these clauses. They operate under slightly different stages of relationship in the contract. Arbitration clause is a promise within a promise because there's an agreement, then the clause is cited as means of resolving dispute whenever a dispute arises. That is what they submit to. Now, that clause promise within the promise embedded directly into a standard contract to handle future disputes that may arise during the business relationship. Arbitration agreement, on the other hand, is a standalone contract drafted after a dispute has already explicitly agreed to take the existing dispute over to an arbitration. You can see the difference. One is embedded in the contract futuristic because anytime people arise, they submit to arbitration. But why the other one? There's already a contract existing, a dispute that arises. Then an agreement is reached to submit to arbitration. Then the party will proceed. You can see the difference. It's good for us to get used to it. The role of the Nigerian court is to give effect to the sanctity of the agreement of the parties to settle their dispute through arbitration. In other words, Nigerian courts play a supporting role in arbitration proceedings by providing assistance whenever it's called upon to do so. The judicial powers are actually limited to backing the arbitral process by compelling parties to fulfill their agreement and providing enforcement measures for awards. That process has been explained, and normally the courts are actually in supporting role and not interfering. Though in the past, yes, it will be said that the role of the courts sometimes could hinder the arbitration process. Hence, many of the parties prefer to use 6 assignment days as arbitration seat in order to avoid the long process of litigation. Now, court intervention in arbitration under Nigerian law, in Nigeria, the enforcement of arbitration agreement aligns with the principles well established. It's called an avenue. It's an old English case which requires disputes to be resolved through arbitral arbitration based on the agreement they elect, having a clause in that contract. However, any delay in invoking arbitration rights or active participation in litigation may amount to waiver, allowing it to be proceeded in court. So parties are expected, once one party decides to go for litigation in spite of the clause or agreement, then the other party is expected to go to court to submit an application or apply for stay proceeding. That has well explained. This approach upholds the integrity of arbitration agreement and ensures it as a waiver by the court. Now, what happens once the court grants a waiver? It's still proceeding. The court jurisdiction is still intact, but what happens is a suspension, not strict of jurisdiction during that process of granting a stay. And the court of law assists in attendance of return witnesses and ordering interim measures of protection to preserve aspects of evidence before or during the arbitral proceedings. Now, these are situations, there are situations where the refusal by party to arbitrate could be justified. That is just an exception. The Supreme Court has clarified that the party cannot rely on an arbitration clause if there is no genuine dispute to arbitrate. Even the clause is there, but when there is no genuine need for you to arbitrate, the court will not come to your aid. In the case of Sakamori, Consortium Nigeria Limited, and other Lagos Water Corporation, the Supreme Court held that an arbitration clause cannot be invoked to frustrate the recovery of debt that has already been unequivocally admitted and acknowledged by the debtor. What the doctor has acknowledged that, yes, he borrowed the money, but he has not paid. He cannot give rise to an arbitration. In such situation where liabilities are admitted, there is no dispute to refer to arbitration, and the agreed party is is entitled to approach the regular courts. That is just one situation. Now, I look at the issue of, from the point of view of the new arbitration law. And the issue of an award, an arbitral award cannot execute itself. It's not self-executory. And it has to go through the process of courts so as to compare compliance. So, under the Arbitration Obligation Act 2020, an award, whether domestic or international, is recognized as binding and will be enforced by the High Court or Federal High Court. Upon the written application, the court will enter the award as a judgment which can then be enforced like any standard court judgment. Nigerian court will not issue arbitral awards, as has been said, on their merits. Judges cannot litigate the facts or correct errors of law unless specifically provided for by the parties agreement or the law. There are only limited grounds for the setting aside of the award. So it's strictly now, and because the third ground includes incapacity of the parties, invalidity of the arbitration agreement, lack of fair hearing or proper notice. The subject matter is not capable of settlement by arbitration under the Nigerian law. Then they are more conflict with Nigerian policy. That policy has been well established.
Yes, Mr. Lincoln, you have 2 minutes more.
Yes, I'm not currently trying to. What I will say before I round up is that the introduction of the repeal and enactment of the 2023 Arbitration Act has actually provided a very enabling legal framework by which arbitration is practiced in Nigeria. And as a follow-up to that, what the federal government did was to bring about what they call a new policy on arbitration. And that policy has actually brought about a lot of innovations with regard to place of arbitration and issues regarding the alternate clause, which of course should now form the basis of arbitration agreement or clauses, where they now have to introduce the issue of a three-stage approach, starting with what they call negotiation, then mediation, before arbitration. So the process they have introduced is to make sure that we expand the domain of arbitration so as to be able to attract foreign investment. Now, in conclusion, if one party files a lawsuit instead of submitting the dispute to arbitration, the other party must promptly apply for still proceeding before filing a defense or taking any other substantive step in the suit. If an arbitration clause does not completely strict cause of introduction, but truly suspend the court's power to hear the case. Arbitration clauses or agreements are generally binding, and the willful refusal to participate does not invalidate final arbitral award. The relationship between the courts and arbitral tribunal is defined by the principle of minimum judicial affairs. Judges are encouraged to exercise restraint, disallowing litigants from using the judicial system to frustrate or delay arbitral proceedings. Ultimately, Nigerian courts treat arbitration as an autonomous dispute resolution mechanism. It avails only to rescue the process from being frustrated or stalled, sometimes stay there. Nigerian courts have repeatedly taken a high stance against parties attempting to bypass agreed upon peaceful resolution process or agreements. With this, I want to encourage us as lawyers to always ensure that the provision of Article 26 12, I think from paragraph 8E, to go together to help in particularly when you are dealing with issue relating to order 3 to 17, where you are supposed to issue a certificate that you have advised the bank relating to the strength and weakness of the case, and we're going to make sure once there is a clause of agreement, you make sure that you advise the bank adequately prior to litigation. Thank you very much.
Thank you very much. Salipo, thank you for your intervention, or if you like, your contribution. Some people took it from, if you like, the practical angle, discussing this paper. Well, thank you very much, Mr. Lipo. Shall we go ask you good afternoon? Now, the topic for discussion this morning is the role of courts in enforcement of arbitration clauses and agreements in arbitration. Arbitration clauses and agreements in arbitration. Now, I want to try to bring it closer to all of us, if I may. We've heard about the dollar being a coward runs away from, because those who come to invest, basically you're looking at the ROI, return on investment, the safety of investment. So when the investment is somewhat challenged, they think that it might tie down the capital. They tend to be sharp. That's why they say the dollar is a coward, wants to go away. So, and of course, they want to go to a more stable environment where they are sure that their investment will be to yield within the relevant time, not tied down, and not tied down in any politics. Now, and so they say the dollar is a coward, it's sharp. And then the young practitioner begins to imagine, this topic, arbitration, is really not better for me, it's for the big players, the big lawyers, the senior counsel, the senior advocates. We have one very eminent one here, my president, today. And so they tend to think, oh, this does not ordinarily concern us. It's talking about commercial transactions with international flavor. I think it's important for us to appreciate that the topic is not just about arbitration clauses in the context of multinational agreements. No, it's any agreement. In other words, when you draft agreements of a commercial nature upon which a disagreement arises, you are advised to put in there an arbitration clause. So it's not talking about what we cannot, what's unattainable, what's beyond our reach. Try to bring it home to us. We can put in, or we should, it's advisable to put in an arbitration clause because your matter will be tied over the courts for a long time. That matter's in courts now for, well, an embarrassingly long time. Not because the judges are not in defense of the institution. Because in nature, maybe pro bonos, begin again, de novos. Okay? I couldn't put a judge down in a particular position because of one particular matter. So judges are transferred once in a while, and there's a sense in that, there's a benefit in that. And then your case gets cut off or stopped. So, but if you put in the arbitration, whatever, arbitration clause and all that, the matter may ordinarily facing go to arbitration. Alright? So it's important that we appreciate that. So the dollar thing shouldn't shouldn't frighten anyone. I hope it's not a topic for me, so these are the big players. Now, what's arbitration? I love defining it simple. An alternative method of resolving disputes outside the traditional court system. That's all. So avoid the courts. Litigation. And all that comes with litigation. Of course, I know that there are reforms are going now to expedite hearings and all that. Most courts are not recording anymore. Digital and so that reduces the time that which the court has to record. If you're talking and I'm recording, I'm not trained in never to be watching, I'll take the time to get you. But if you're talking and the digital device is recording you, I'm not more focused. I will rise early, we finish early. Time is constricted, time is saved. Now, my Lord, in talking about so like I said, outside national court system, where a third party, the arbitrator, who is the judge outside of the court system, decides the matter. That's all. My Lord, we're talking about the legal framework for, and of course, because I've also referred to it, that is the Mediation Act, the Mediation Act of 2023, and so, very well. Sort of enlarge, I'd like to, before we ask questions and without contributions, enlarge the discussion to include mediation. And the difference between arbitration and mediation is arbitration is a neutral party who decides the question. And what is it? Binds the parties. Like the customary arbitration, which all have know that. Then for mediation, there's also the third party who does not hand it down, but encourages the parties to themselves agree. And so if we embrace this, you are going to find that half of the cases, if not more, in the courts won't be, and the lawyers will keep smiling. From this side, I've seen a reluctance by lawyers to embrace. They think that when they go to the area, the Monsignor Courthouse, the director is here, I think she should have been in my office panel, but that's by the way, the director of the Monsignor Courthouse, Anglophobia, yes. Now, so when they think that, so when they go there, you'll find that before you know it, in a matter of weeks or months, matters are decided, your fees are in, and then you go and your turnover will give you much more than stop in one place, and then you do your transport every because I'm congested. You get your days once in 2 months. But this is part of it. I mean, appearance fees. That's what they call it. So lawyers are saying using this platform to encourage us. Let's look at our rules properly. Provisions concerning arbitration and mediation. And let's this will benefit even the lawyers. We're talking about reforming today and securing tomorrow. With those comments of mine, I want to, shall I say, declare the floor open for comments and questions. Let us see, sir, shut up. You have the floor, sir. Please take the microphone. Thank you.
My Lord, the presiding judge of this session, let me first of all commend my Lord. At the appropriate time, I will ask for extension of time in advance. I commend my Lord because it's a square peg in a square hole. It's very much at home with every topic. But I was shocked this morning that for the first time in my life, my Lord was shot for words for 30 seconds. He couldn't react to the paper delivered by Honorable Justice Bessie earlier. And that was understandable because it was such a brilliant presentation. Thank you very much. Having said that, let me make a few comments. First of all, I want to congratulate the
multi-door house of Edo State. They are doing a wonderful job. I'm privileged to practice in other jurisdictions, so I know what I'm talking about. Personally, I had a dispute that lasted 13 years in court in this state, from one judge to the other. After some time, we transferred the judge, we started all over again. It was a very problematic case. And it was resolved at the multi-door house within a few months after it went there. And that was the end of the matter, and everybody went home happy, including the lawyers. And that's where, with respect, I will raise objection that appearance fee is not the issue at all. I think it's more of a question of transition from what we are used to what we are becoming used to. We are used to the traditional form and all that, but as time goes on, more lawyers will embrace arbitration and other alternative dispute resolution mechanism. Now, I have a question. There's a serious resistance by multinational companies against locating the venue of arbitration in Nigeria. It's a problem. In one arbitration I was involved in, the lawyers, the dispute, the witnesses, the claimant, the defendant, were all Nigerians. We carried ourselves to London to go and resolve that dispute. And when I looked at what value that would have added to the economy of Nigeria, even etiquettes that could have been saved, time that could have been saved, and so many other things, I was wondering. But that appears to be in that one I was a counsel. In another one, I was a panelist. Everybody, we again carried ourselves to London, but that's not the issue. The issue is that the first motion filed by the defendants was that they wanted the panel to direct that the applicable law would be Nigerian law. And we were surprised. We said, no. If you seriously want to pursue this motion, you know what the outcome will be. It will be in our interest because we were charging per hour. So if you bring all sorts of applications at the end of the day, but we didn't think it was fair. Anyway, wise counsel prevailed and the application was withdrawn. So I believe, rounding up, that the reason why there's that resistance is because there's a vote of no confidence on the Nigerian system, court system, whether we like it or not. People, my lords, have referred to it this morning, debates and so on, matters being tied. Even after an arbitration is done, you still have the issue remaining in court for another 7 years. If it gets up to the Supreme Court, it may even be slightly more than that, if it's fast, to find out what the final resolution of that matter is. So what do we do? I will leave the chairman of session to direct the question to whom he thinks is best suited to answer it. What do we do to make Nigeria the international arbitration center in Africa, at least to start with, before we talk of outside the continent? Thank you for the opportunity.
Yes.
I love the chairman of session. This permits me to stand on the existing protocols. I want to join my voice with others to commend superlatively the presenter, my Lord the presenter, and the very strong panel. I had to be here quickly because when I saw the composition, both the lead speaker and the panel, I discovered that it was composed of veterans in arbitration. Some of us are far away from arbitration. I'm a fellow of history of mediators, but I've never gone into arbitration at all. And so I came here as a student to learn. And I've learned so much today, and I want to highly commend the presentation. Now, we are talking about enforcement by the courts, but I want to look at lawyers. Thank God the lawyers are here. I think it starts with lawyers. I see arbitration clauses in almost every agreement, but there is a count. Not comprehensive enough. I think that is why they neglect it. It's always so scanty. You just see one paragraph to be subject to arbitration. They leave it at that. I think that's their difficulty. When it's so vague, then it's difficult to implement it. So I want to plead with lawyers, like my brothers have said, and like all of us have said, it's in the best interest of all of us in this profession to implement arbitration. If we cannot take anything away, we should be able to take it away that. Henceforth, in every agreement that the lawyer prepares, there should be a comprehensive arbitration clause, so that it can be enforced. Not that was to put competent people, that's what they said. Not that was the qualification of the arbitrators. You stipulate things there to make sure that even the way we nominate them, sometimes you say this party will nominate one, you put all those things comprehensively. When you see a strong clause that is comprehensive, then eventually when there's dispute, people will now narrow down and look at the clause that have been put there as a measure, a proactive measure, and lawyers should be proactive. So I want to say that we should take it with all sense of seriousness for our mutual survival of justice. Even you lawyers, you come to court, you have been one place for 10 years. After 1 year, your fee must have finished. You are not surviving on the appearance fee, which I just not telling us in the court that they didn't pay the appearance fee, and then we keep on sympathizing with you. But I think it's in your best interest, you collect your fees. Under 1 year, you are through with it, and you can be your chambers quietly and enjoy that fee, rather than come to court and still even your transport be exhausted in 10 years that they pay appearance fees. So we should do something. I have a question higher. Some situations arise in the courts which looks complex, but thank God for this strong panel. They may be able to help us. I've given about 2 judgments now, because you said, and which is correct, according to AMA, which appears to be the ground norm on the subject, that arbitration awards are not subject to appeals to courts. But under the AMA, there's a procedure there for enforcement. There's also a procedure whereby you can send it aside. But some situations arise that are reasoning that these 2 cases where I gave judgment. Look at how it arose. The case was in court, land matters, and evidence, the pleadings showed clearly that the matter had been subject to arbitration, that it had been decided arbitration, almost raising the point of res judicata, that arbitration had decided this matter. And then the other side said, no, there was never any arbitration. It now became the contest, a live issue in the trial, whether there was ever arbitration. I won't tell you how we resolved it But it was hot because evidence was not led about an arbitration, which almost looks like I was sitting on appeal over that arbitration proceedings. It was delicate. I had to do extensive research. Thank God for AI that I found leverage in strong authorities. I leveraged on and navigated my way out of it, and the judge saw it that the judge found his way out because they put me on the spot. So, but I want this very strong panel to enlighten us, because sometimes the problem is not that the people refuse to submit to arbitration. It's not that somebody is not trying to stop arbitration. Sometimes the problem is that arbitration has ended, and they thought that the matter had been resolved, and then they filed action in court, and then in the pleadings it came out that this matter had been concluded by arbitration. I want that issue to be. I think let's share something. Thank God this final thing is here. Goes to London, goes to South Africa. I'm trying to start off this, not new to them. So I want a robust discussion on that. Thank you very much.
Thank you very much. First, I would like to thank the guest lecturer this week. It was so quite extensive, incisive, and very provocative. I'm an arbitrator myself, General District Arbitrator in United Kingdom. And I believe these are not next gathering. Whatever we say shouldn't be used against us. When the case of Ahmad, the museum came up before more, but it came up before me and I was really defiant. I look at those. I said, well, under the Federal High Court Act, Section 18, the Act is enjoined to promote settlement. And under our court rules as well, we have another for arbitration and all the rest. And we have multi-courts and multiple courts in Abuja as well. So when I was reading the file, and I look at the parties, these are banks of limited guarantee, foreign banks. It will have caused a lot of indebtedness, so to speak, to one side, I don't know the side. But then, if they have gone to arbitration, these things would have been settled. Thank God they have withdrawn the whole thing. If they refile, I will assign it to Professor. Because you have seen my own mind now. Yes. So I just read the whole file. Because of action, what led to what? Why that instruction and that? I think some players are members of the team, I won't say no. For now, I would like to say that we are all enjoying to promote arbitration or alternative dispute.
Yeah, okay, once more, Mr. Wibo.
Thank you, my Lord. My Lord, let me join my voice to appreciate the lead presenter for that very erudite presentation. Like my Lord Justice Akero said, most of us have come here to learn, and sincerely I've learned a lot from what have been said here today. I am constrained to ask, first, it will appear that the jurisdiction of arbitration is limited to commercial or trade transaction. If I am not correct, then I want to plead to be educated more on this, because I try to draw a distinction between what we are discussing, because most of the conversations we've had will tend to center more on commercial, trade, partnership, as it were. On drawing a relationship with these, with what we experience at like plea bargaining, restorative
the kind of justice. So if we have such an engagement, and of course they are now bringing such an agreement because it comes by way of an agreement before the judge for the purposes of committing such agreement to be taken as a judgment of the court, and then the court makes pronouncement on such, because most of the arbitration agreements are brought before the judge for the purpose of making pronouncement or like ratifying to be the judgment of the court to bind both parties. Now look at it from that. I am worried that there appears, because I'm not taking out time to look at the Arbitration and Mediation Act itself in details, except maybe after today I'll take out time to look at this. Does the jurisdiction of matters to be determined for arbitration and mediation restricted to civil or in terms of commercial partnership or trade disputes alone? If not, then we begin to look at how to expand some of these things so that we begin to consider some other areas so that we don't limit ourselves to conversations on this. And then I'm also concerned about the fact that the provisions of Order 26, which my brother Mr. talked about, will appear cosmetic in our...
You mean your friend?
My friends will appear a bit cosmetic. Lawyers just prepare statement of claim, the writ of summons and statement of claim, and then just insert that provision. Because the rules of court require that when filing a writ of summons, you attach, you put all those things, without necessarily educating our clients or having to explore the provisions of the rules generally with respect to considering the import of that provision in our rules, so that we take it more seriously. And I've observed too, I know that when we are discussing the issue of arbitration, emphasis appears to be more on the fact that there is a clause in an agreement. Now, in a situation where there are no these arbitration clauses in an agreement, I know also that the courts, there are cases that the courts, there are court-referred matters to the multi-law court house for arbitration or for mediation. Can the parties sincerely explore arbitration where there are no specific provision in an agreement between them for the purpose of arbitration? And then finally, my Lord, if we begin to take advantage of the provisions of this armor, and we're discussing it because it introduces time, it tends to promote justice, and then of course parties are able to resolve without real disputes instead of going through the rigors of real litigation. Can our political parties, particularly under cases that are intra-party, take advantage of this provision so that all the pre-election matters that are within the corridor of a particular political party are resolved at that level, so that we don't begin to bother the courts or labor the courts with some of these disputes that are intra-political party and are resolved at that level, so that we don't have to trouble our courts, the state high court, and then the federal high court, my Lord, Justice Babatune to be disturbed about what happens in various political parties. Hello, that is my conclusions. Thank you, sir.
Thank you very much. Yes. Yes, the gentleman. Yes, the gentleman. And then after him, we'll take 2 more questions and then we'll be done.
Thank you, my Lord.
More comments.
May I also stand on protocols already established? You know, while I agree completely with the learned Silk on the fact that Nigeria is a difficult choice to be made as a seat of arbitration, I also want to note that the role of the courts in the enforcement of awards and arbitration clause is best served to achieve the entire purposeful advantage of arbitration, which basically is resolving commercial disputes in a timely manner. And that's the main reason people go to arbitration. But my lord, the role of the courts in Nigeria with respect to arbitration, no doubt, as it is exposed in your paper, has grown very positively from interference to support, from old cases to recent cases, and even the Mekonye case. Because when you see courts coming into arbitration and staying in arbitration, in fact, there was a court that granted injunction to restrain an arbitral proceedings, and of course that case went viral around the arbitration community globally. We have moved from that stage to a stage where even a court in Nigeria is now saying, even though the clause made mention of a non-existent appointing authority, the clause is still valid. So that's a posture of a movement from interference to support. But my lord, the main issue is not really that the courts are not performing their role as it were. But I think the issue is how the courts are performing their role. And that brings us to why disputants find it very difficult to make Nigeria the seat. Because our judicial process is slow. And in the end, by the time the court does a very good job in playing their role in supporting arbitration, the time factor eventually reduces the importance of that role that they play. I'll just bring a statistics to, before I ask my question. Yes, I have to bring it in context. Because in Nigeria, statistics has it that pre-AMA awards are enforced from commencement to finality at school, but we get there. Pre-AMA was 30 to 60 months. Post-AMA.
Look, I think that you have made the point. Now, the statistics is perhaps evidence you are all the supplementary you made. Go to your question.
Thank you, my lord. My lord, the question is, what is the solution to resolving the delay issues in our court system, particularly as it involves arbitration?
Thank you. Yes, okay. Yes, Mr. Iwayo. Okay.
My lord, the chairman of session, please permit me to...
Please go to the point.
Yes, my lord. I want to also thank my lord, the paper presenter, for the very vivacious way the paper was presented. My lord, I want to narrow my question to customary arbitration. There was a case I read involving a customary decision from the Palace of the Oba of Benin. And in court, the defendant said, no, I did not accept that decision when it was handed down. And the decision of the High Court here was that, well, if you did not accept that decision, you should have said so before the face of the Oba. And the court relied on a Court of Appeal decision. I read the Court of Appeal decision, and it said, if you are not accepting the decision of the Oba of Benin from the customary arbitration, you must look the Oba in the face. You must reject that decision before the face of the Oba. And I said, as a Benin man that I am, can it ever be possible for any Benin man to look at the Oba of Benin in the face and say,
you don't need to look in the face, look to the right and say,
my lord, my question actually is, whether you look at the right or you look at the left, can you say to the Oba, I don't agree with this decision? That's the first. Lastly, sir, very short, sir. Now, decisions flowing from the multi-law court and other arbitral bodies that have made consent judgment in our courts. Now, what is how do we see such consent judgment in the face of a situation where you are required to present judgments from contested cases? Can we say those consent judgments pass for such requirements? Thank you, my Lord.
Yes, last we'll get there. Yes. Yes, give it to the gentleman who's kept over there. Yes. I'm pleased to the point.
I'd like to appreciate.
So I think the lead letter has been appreciated enough. Your question. With respect to another cause.
Thank you for the opportunity. I just have a contribution actually, not a question.
Very well.
So,
yes, you have the floor.
So my contribution is that my concern is enforcement and confidence in the process. Many parties still prefer litigation because they believe a court judgment carries more authority. The challenge is therefore not promoting litigation. It is ensuring that mediated settlements are respected, enforceable, and trusted by disputants. Another point that I wanted to raise was the fact that a lot of people are not aware of this. I'm talking about the average citizens apart from legal minds. So perhaps more attention should be given to public awareness. Many citizens still do not know that mediation and other aid mechanisms exist until they are already deep into litigation. The problem should not be about appearance like the first speaker noted. It should be about increasing awareness and considering that as important as reforming the procedures themselves. And just to...
No, by the way, thank you very much for your contribution. The director takes note for the something about that. Yes, the last question. Because we have to answer this question. The last, yes? Give her the microphone, yes. The camera.
Thank you very much, my lord, the chairman of the session. My question is what happens where there is an arbitration clause or there is no arbitration clause, but a matter is in court and the court in its wisdom has referred the matter to ADR and the parties in both cases are willing to proceed with the ADR process. But it is the lawyer who is assiduously, ferociously working against the success of the ADR process.
Yes.
And there are parameters that can be put in place to checkmate the activities or the influence of lawyers.
Thank you very much. I think that is a very good question, particularly your employment of the word ferocious, but that's what we are seeing. I'm sure that the lead president will be this now must not answer the question because we have time is limited, interesting situation we're having, or we have to close so this session can convene. So I love the lead speaker.
Thank you very much to Learning Senior Advocate Chief Ferdinand Obi. Thank you for essaying, thank you for your contribution and my lords that have contributed, and the very engaging audience, indeed members of the great Lion Bar. I will not always stop praising you, the most vibrant bar in Nigeria.
Of which you are not
Let me say, I thank you so much for your contribution. Indeed, that issue of venue of arbitration is very worrisome. It is attitudinal, and most people, virtually everybody who wants to do arbitration in Nigeria, when you can go to London, and as we know, even though we never got to experience it while we were in practice, you are paying in foreign currency. We are also aware that from the moment you board your flight, your hours, your billing has started running. Why would you stay in Lagos? If I'm the one, I will not stay. I will not stay. No matter my principles, no matter how I believe in it, we will go to London.
Well, before you continue, we all hear the NSC advocate wishing this is where headed in Nigeria. We salute you.
So that is it. And then again, we all know that before now, we always used to encounter Juson strike. It is only in the last couple of years that we'll not be hearing about it. Sometimes I really wonder, is it never pay, what has happened? People now, some time ago, Justice tried to shut down the court for several months. And then that led to this apathy that, oh, what if there is strike, what will happen? Oh, this property, oh, this ship is in the deep ocean, we cannot leave it there. And then gradually the confidence started waning. But as my Lord, Justice Aki, Honorable Justice Aki has said, and Honorable Justice Quadri has said, it is in our hands. We should now reorientate ourselves and try to ensure that we bring it back so that Nigeria can be a hub for arbitration in Africa. My Lord Honorable Justice Aki mentioned 2 matters in his court, and even though he did not tell us how it ended, we know the reasons why he could not do that. But I want to believe that perhaps with the parties, they could have decided to enter into an agreement, arbitration agreement, which is entered after a dispute has arisen. And parties would simply have been encouraged, and they could have said, the dispute concerning the ownership of the property at number 2 Boundary Road, Benin City, shall be now be referred to arbitration. So once the dispute has arisen, they can have an arbitration agreement, and then they can go into arbitration. My Lord has others, will also answer some questions from the other panelists. So I'll just quickly answer the one raised by Pius, past chairman of the bar. Arbitration, is the jurisdiction of arbitration limited to trade and commercial disputes? No. The answer is no. When Mrs. Oahiri was speaking, she talked about commercial arbitration. So it's not only commercial disputes, and my Lord, the chairman of session, also mentioned it. It is for parties to decide to insert arbitration clauses, and as my Lord has said, ensure that your arbitration clauses are explicit and leaves no one in doubt. Don't just say there's a dispute result of arbitration. Decide on the panel. The plaintiff will choose member 1, you will choose member 2, both will choose the chairman and another. Be explicit so it leaves no room for doubt. So, customary arbitration has been recognized by the Supreme Court. So, it is very important that we know that it is not only commercial, it is the decision of parties. And this is nonetheless to be encouraged by counsel who draft arbitration clauses and agreements. It's lawyers. So, we must all be interested in arbitration because I tell you, if you ask Leonard, you can put a lot of money in your pocket, including foreign currency. But now, what I'm trying to say is that arbitration is very interesting, it's robust, and also there's a lot of money to be made from it. Let us not keep thinking that everything must be about litigation. Arbitration is smooth, it's fast, and it's very interesting. I encourage everybody to be involved in arbitration. Thank you.
Well, yes, our discussant is Ivory. We want to speak to, just a moment, let's have a Yes, we want to speak to one member, that's right, we want to speak to from the questions. Is it happening?
Thank you very much. To the question raised by my Lord, Honorable Justice Akigero, he asked what would happen where parties dispute whether an arbitration took place before or not in the court proceeding. Now, when arbitration takes place outside of, it's normally outside of the court proceeding, and it's normally confidential, it's private, and all that. So it's the parties who were involved in the arbitral proceeding that would say whether there was an arbitration or not. The Supreme Court has held, in recognizing customary arbitration, that where there is that argument, all the judge needs to find out is whether one of the parties, when that decision was handed down, vehemently rejected it. Where that decision was being made at that customary arbitral level. Where there was such a reaction that he was rejecting it, then you cannot say there was a binding arbitration award at the customary level. That was what Mr. Mario was alluding to by saying, looking at the Oba's face. It's not only the Oba, it is why that decision is being handed down. If one of the parties was dissatisfied, he or she had the opportunity to reject it there, not necessarily looking at the Oba's face. If they reject it there, then it means it is not binding. Because one of the principles of arbitration is party autonomy. the party agreed to be bound by the outcome of the process, irrespective of whether the person handing out the decision is a judge or not. Because arbitration is not only exclusive to lawyers. My former principal, Chief F.O. of the SAN, can attest to that. We have a lot of people from different spectrums of life sitting on arbitral panels and handing down decisions that we cannot set aside. And they do it well. And that is why that distinction made by Mr. Olivo about what an arbitral clause is and what an arbitral agreement is very, very important. You have the clause in the contract, pre-dispute, that is before hostilities arise. And you have the agreement agreed to after the disputes have arisen. Parties will not say, if the court is saying, oh, go and explore ADR, the parties can sit down and say, okay, our lawyers draft arbitration agreement. This is what we want the arbitration agreement to be. These are the qualifications of the panelists who will hear and hand down decisions to us. And this is how much we will contribute to the process. All those things will be spelled out. That is what party autonomy is all about. And it will, at the end of the day, when an award is given, it will be recognized and enforced by the courts. Thank you very much.
Thank you very much. I quite appreciate the questions that were raised. You have been answered. The other dispute that is not actually subject to arbitration is when you interpret documents. It's only the court that can do that. Instruments, for instance, constitution, documents, and all that. The voice matter also cannot be arbitrated. And I gave one example that if a debt has arisen and the other debtor agrees that they are owed, there is no dispute. You just go to court and draw your debt. So those are the ones that are excluded. Every other thing can be arbitrated. That is why in construction industry, marine, everywhere, arbitration. So what the chairman of session advised and admonished before we started this question and answer session was that lawyers, we are the ones that draft instruments. It is on so the hardest part. It goes on us to ensure that those contracts will serve clauses so that once those clauses are there, then what happens is that when this thing arises by what we are just discussing here, the first result is to go for arbitration. Then by that you have a lot of cases that you can handle, that you can call upon to come and arbitrate. Then the issue of the parties don't normally choose outside this jurisdiction for arbitration because of the delays. That is correct. Delays are already there, and we have their processes. Yes, but what normally happens is
I said that question has been made.
I just wanted to just say, but the new attitude flowing from the new act is that, as I said, the federal government has come up with a policy on arbitration. It was actually inaugurated last year, 2025. It's already in vogue, wherever there's domestic contract, without commercial or whatever, the ministries, department and agencies is now mandatory that they must live in Nigeria and seek of arbitration. It's not compulsory from that point of view. And in that way, they also they establish what they call timelines for such dispute to resolve. I think for the first court is 30 days. Then 60 days, while the other one is 270 days at the court of appeal.
Yes. So thank you very much. I think that your address we are behind time, round up this session. But very quickly, I want to say that it's a matter of fact. It's a matter of fact whether or not there was an arbitration. So make a finding, and then so when the party says, one says there was none. Determine the evidence, whether there was. So that is not so bad. And then very quickly, fine, the issue of whether arbitration is limited to commercial agreements. No. Now parties can themselves agree and go to arbitration. And how can we do that? Is the matter no clause? So they can't come. It's matter. Can we not rather go to court and file and spend 10 years? Can't we? If you could agree, why not? Arbitration. Commercial. The issue of resigning out of commercial arbitration, there is really practice now of making the parties sign some document to say we are fair to be exactly the word, you know, I stutter sometimes. Be bound by the when you make them do that, it's difficult for them now to say no, I don't believe it's against them. There was a matter of quickly multi-law directors here how to invite the parties. Now, for enforcement, when you go to mediation and then you reduce to an agreement and you sign, it's brought to the courts for endorsement. That was to put the implementation of the courts on the agreement. And that makes it now enforceable by our beliefs. And so they came and they said, you know, that of course the point is they had to be bound by that which they had signed. That's what I was resolved. So when it's the last word, my closing remarks, this is a new deal. Let's embrace the practice, and I'll show you it's very rewarding for the lawyers, and of course, so the judges themselves will not be killed. Also rewarding. Also the rewards also the judges. So I want to thank all of us. It's an interesting one. I see that we're not eager to leave a talk, but we must draw this session to a close for the next session to continue. Thank you very much.
Thank you very much, Milan. It's been quite an amazing session, and I'm sure we will have new combats for ADR. Milan, we have here with us the distinguished Secretary to the Edo State Government, Musa Umar Kilo Esquire, and his delectable. And glad to have with us also our colleague. I think there are two takeaways, or should I say one very important takeaway for me, which came from the contribution of former Chairman Pearls Idomunyawo Esquire. And that is the fact that political parties should refuse pre-action protocols in their constitution to forestall multiplicity of suits. Many people don't know that the Nigerian Bar Association has a pre-action protocol in our constitution. That is why it is very difficult for you to see a lawyer taking the NBA to court. So we should actually push that by way of advocacy and obviously for part of our community. And for Mr. APC, sir, I listen to you quite frankly, and I hope we lead by example, so that we will both make recourse to mediation, conciliation, or even reconciliation in the matter we are doing together. Thank you very much. On this note, of the treasurer of the bar, Mrs. Joyce Thomas, to give you a vote of thanks. Please put your hands together for us.
Thank you, sir. Thank you so much. We appreciate you all. Thank you, sir.
Beloved, we are having a session right away. Please, all beloved brother judges, Secretary to the State Government, Mr. Omar Kilo, please, we appeal to you to please join the photo session. Then our distinguished guests can join the photo session. Just a few announcements while the photo session. The learned seal and our distinguished senior lawyers seated in front. We may be able to join the photo session, please. just a few announcements while the voting session is going on. The second plenary is starting immediately, but we want to remind us, this is on a much sadder note. We have a valedictory service tomorrow, or a light state service, I beg your pardon, in honor of our late Professor Faith Osadolo. The service is for 10 a.m. at the foyer of the High Court. Okay, it's for 10 a.m. at the ceremonial hall here. Just this same venue by 10 a.m. tomorrow morning. Then after that, we have the chairman's call by 2 p.m. at the Samuel Ogbemudia Stadium. It's part of the Law Week activities. By 2 p.m., our Lion FC will be engaging NBF Forum for the Lions Cup. Then also the Law Week culminates with a gala night on Friday by 5 p.m. at the NBA Secretariat. So please, tomorrow by 10 a.m., we are required to be here to honor the immediate past Solicitor General of Edo State, Professor Faith Osadolo. Then by 2:30 p.m., there is a football match at the Samuel Ogbemudia Stadium. Then the gala night for Friday is by 5 p.m. It's at the NGA Secretariat, just by the NGA Secretariat, just behind the High Court there. We don't know if the people. DJ, please give us a brief musical interlude for 5 minutes. We can stretch our legs for 5 minutes briefly as the second plenary session commences immediately. While we are interacting with one another, we will give 2 minutes to, we'll be speaking of technology and AI, so we'll give 2 minutes for someone from Law Pavilion to address us.
I've been seeing you, but somehow we don't get to speak on the shake hands. How are you, sir? Wow. This is I like this. You're good at this. That's fine. Whatever it is. It's an every. Very well. I said it. Is that your phone?
Not the chief judge of the state, also is present. Esteemed senior advocates, members of the bar, the NBA chairman and his executive, all members of the NBA of the prestigious Lion Bar. My name is Olomo from Law Pavilion. Okay, please, I want to plead that if we can have our seat so that we can grasp one or two from what I'm saying. Okay, from the different sessions that they have been had so far, a lot has been said about AI and technology. And I just want to take 2 minutes to progress on that. Okay, so the importance of AI technology, IT, the legal trend or the legal sector cannot be overemphasized. Traditionally, before now, we do normally use the indexes to go through the index runs to get authorities. But now, as your fingerprint, we have access to all authorities. And now we've gone so far to develop the AI, which can assist massively both in legal opinion, both in your document review, drafting all your documents, as well as drafting all your contracts and agreements. So in few seconds, you can draft your final meeting address in less than 5 minutes. In less than 5 minutes, your final meeting address is ready. All your legal briefs, you can do them with ease, so that and with that you can meet up with your various deadlines. I'll not be able to exhaust all that we have about the AI. I'll be dropping the flyers which has a lot, which displays a lot of the features of the AI, and you can as well with us outside to know more about the AI. The importance of the non-Babylon AI in the legal industry is something that every lawyer needs to address. Because when you have a lot of legal research work to do, a lot of matters to attend to, you need something like AI, the non-Babylon AI, to help you with your brief, to help you with your research work, and a lot, even for a lot, they need the AI as well. So please do well to visit us. If you are a subscriber to the Babylon, please kindly meet me outside so that we can operate your package. And if you have any questions, if you have any complaints, we can meet you outside as well. I don't think if there's any question, I will be glad to entertain. Any? Why does she get it? In the session, okay, thank you very much.
The afternoon session will be starting by 1:30 p.m. Okay, please, let's be seated so that we can commence the session immediately. Please, organizers of the Law Week, help us appeal to members to join us in the hall so that we can commence the afternoon session immediately. The chairman of session is already around, the Lord Honorable Justice Peter A. Adikero. We have our speakers here present, the Vice Chancellor of the University of Benin, Professor Edoba Omorege, Senior Advocate of Nigeria, is here ably represented by Professor Chukwu Ogba. Mr. Samuel. Please, no pictures in the hall anymore. We are all starting the session, please. Let's be seated, please.
Thank you. Please, can we bring the sound down a little bit? Thank you. Please, those of us standing, may we be seated. We are about to commence the second session. Hello. Please, can we warm our seats? Thank you. It's been a very engaging week. And this practically takes of sessions is the last for the long week with other programs continuing tomorrow and then the day after tomorrow. So let's take this formal session in memory to remember for many years. So we appeal to the people at the back. Can we warm our seats, please? Organizing committee members, can you help us maintain some decorum in the hall? Thank you. Dear colleagues, you have been wonderful. Can we have our seats? We have our guests seated already, and we are about to fire down. God bless you. Thank you. Thank you very much. My Lord, the noble lords here present, the very young, amiable, welcoming, unassuming, and always receptive head of government administratively, the secretary to the Edo State government, and his wonderful wife here present today, Musa Muhammad Ihilo, Esquire. With profound respect, the #1 man at the state level in terms of policing our society and public generally, are doing great work with great network of synergy to police our environment, our localities, our local government areas and our state. We're proud of you. Because you are receptive, is the reason you are here with us with due respect. The CP Monday and Monica. Dear Chairman of the Lion Bar, the Prosperity Chairman, who came in at a time when Providence smiled at the bar via the remuneration of that. So the bar characteristically have christened him the Prosperity Chairman, the Lion Head, Demudia Iridia Osifo Esquire. Our dear past chairman, and particularly here with us, to two of the bar, Ede Asenukwa Esquire, our dear vice chairman of the bar. She does a lot extraordinarily, socially and professionally. We are indeed very proud of you. This is not about designing, but deserving of what you have done, landmark of performances. Iton Ekama Esquire, very seat of the bar. Are they very vivacious, hardworking, unassuming, calm, great demeanor, planning committee chairman of this great 2026 Law Week, my dear namesake Samuel Atoy Esquire. Permit me, beloved, to acknowledge our dear man of God, a great senior lawyer, Pastor Esquire. And indeed, senior lawyers here present, colleagues, security, and the whole of the press crew, distinguished ladies and gentlemen. It's been an engaging week, and this session in particular is promising to be one of the very engaging and exciting ones.
The session is to interrogate the law, path, and policy shaping Nigeria's future through legal and institutional reforms. This topic is particularly couched to embrace virtually all the government of the professional area with regards to Nigeria governance and administration and security. Therefore, aptly designed and with the able leadership for this session, we are proud to have as our chairman for today's session. I am pretty sure that we had prayed during the first session before we started. So we give glory to God for this second session. God take charge and gives us the enablement to enrich our knowledge to His glory. Our chairman is no other person than a very renowned jurist, a jurist of a kind, a jurist that is of some level of sui generis, if you may. Permit me to say the Lord. We generally refer to him as the digital judge of the bench, a distinguished jurist, judge of the High Court of Edo State, Benin City. He attended Immaculate Conception College, Benin City before obtaining his LLB. Honors, beloved, thank you for doing us the honors by standing. We love you. Degree from the University of Ife, now Father Yawo University, in 1985. Graduated from the Nigerian Law School in Lagos in 1986 and was called to the Nigerian Bar on October the 15th, 1986. His lordship obtained a master's degree LLM in legislative drafting from the Nigerian Institute of Advanced Legal Studies, enhancing his expertise in legislative and legal drafting. His lordship began his legal career in Edo State Ministry of Justice, where he rose through the ranks to serve as Chief Legal Draftsman. The lordship also was subsequently appointed a judge of the Edo State Customary Court of Appeal and later elevated to the Edo State High Court bench, widely respected for his contributions to the legal scholarship and judicial administration. The lordship has authored and presented numerous papers on justice delivery, human rights, evidence legislative drafting, and information technology. And this is one catchment area where we refer to your lordship as a digital judge. A clap of praise on the line. He is a fellow of the Institute of Chartered Mediators and Conciliators, ICNC, and a member of several professional legal associations. We have a singular honor and privilege. The Lord's CV is a long one, very encyclopedic. But for purpose of this session, the Lord, we are indeed privileged. And as we have always considered our call, the Lord, you have been here with us from Monday through to today. Please, with a standing ovation, welcome the chairman of the session, Honorable Justice P.A. Ahihiro, the digital judge. That clap was bring in digital clapping. Digital clapping, you can do better. Lord, we love you, and we sincerely do. I most particularly love the Papa's card. A clap offering for digital and Papa's card, please. The louder one. Thank you, Lord. We love you indeed. The lead speaker is a great academic, thoroughbred professional in the profession, done us well, both in the profession and administration of a tertiary institution. Now, no wonder he's a senior advocate of Nigeria. Our distinguished guest is a professor of constitutional law and governance and a senior advocate of Nigeria with extensive experience in legal scholarship, legislative studies, and academic administration. He is the 11th substantive Vice Chancellor of the Great University of Benin, where he currently leads one of Nigeria's foremost tertiary institutions. Called to Nigeria by 1992, he has built an illustrious academic career at the University of Benin, where he has served as lecturer, researcher, and a senior administrator since 1998. An accomplished scholar with over 150 publications to his credit. His scholarly work focuses on constitutional, law, federalism, legislative governance, and electoral regulation, with significant contributions to policy development and legal education in Nigeria. He has also served on national assignments at the National Institute of Legislative and Democratic Studies, NILDS, for acronyms Abuja, where he was Director of Legislative Support Services, providing technical and advisory support to Nigeria's National Assembly on legislative processes and governance reform. He was conferred the highest rank in the profession of Senior Advocate of Nigeria in 2021, in recognition of his contributions to legal scholarship and constitutional development. We are indeed privileged to have as the lead speaker the learned Professor Edoba Bright Omorige SAN, the Vice Chancellor of Great University of Benin, here represented by the Deputy, I beg your pardon, I want to get it right. Please pardon me, Professor Ojuku Oba is here to represent the VC as the lead speaker. We open hands together for him. Prof, we thank you. Sorry, we may have respectfully asked you to stand up when we're reading the citation. The citation also replicates on you and your citation as a professor, great academic. Please give him a resounding academic professor clap. Our next personality coming as discussant in this great topic is a great man. As a matter of fact, is number 3 citizen. Am I correct? In the hierarchy of administration in the state. Amiable, inviting, good-looking, ever sassy speaker of the Elder State House of Assembly. Right Honorable Blessing Agbebaku, here represented by Deputy Clerk Legal, J. Ohiafi, Esquire. Please, may you be standing in his place. Thank you, sir. Our distinguished guest is a seasoned legislator and the Speaker of the Edo State of Assembly with extensive experience in legislative governance, public administration, and representative politics. He represents the Owa West constituency and has served in various capacities within the Edo State legislature since his first election, 2007. He previously served as Chief of Staff to the Speaker of the 7th Assembly and returned to the legislature in 2023, where he was unanimously elected Speaker of the 8th Assembly. In his capacity, presides over legislative proceedings, coordinates lawmaking activities, and provides institutional leadership for the Edo State legislature. He is widely recognized within Edo State's political ecosystem for his contributions to legislative development, parliamentary administration, and representative governance. We are privileged to have the Speaker and ably represented by the Deputy Clerk Legal, J. Ohiafi, Esquire. Our colleague, please, the Senator of applause. Thank you, sir. The earlier made opening remarks that is the engine room, as a matter of fact, is the brain box of the Edo State government and governance. Being the record keeper extraordinary, we refer to the Secretary to the Edo State government. Sir, may we respectfully ask that you'll be observing as you take your citation. Looking very great and ever beautiful, prompt and very, not just reactive but proactive SFG. We love you. It's one of our own. For standing alone, a standing round of applause to the Secretary of the Government. As we take this citation, our distinguished guest is a legal practitioner and public administrator currently serving as a secretary to the Edo State Government. In his capacity, he functions as the principal coordinating officer of the State Executive Council and plays a central role in the administration, implementation, and supervision of government policies and programs in Edo State. He is a barrister and solicitor of the Supreme Court of Nigeria with professional training in law and experience in public sector administration. As Secretary to the Edo State Government, he coordinates the activities of ministries, departments, and agencies, and serves as a key liaison between the government and the executive arms of government. He is widely recognized within the Edo State governance structure and as a central figure in policy coordination and administrative management within the current administration. We are privileged. So we humbly, in regard, Mr. Secretary Sir, we know we have abridged your citation. Pardon us. It's a gigantic one and cantua, if I may borrow that vocabulary. We make welcome the Secretary to the Edo State Government. Please make welcome our dear amiable looking Secretary, Musa Ahmad Ikino. Esquire, one of our own. Can we give him a standing ovation as Secretary to the Government of Edo State? The standing ovation to the Secretary. You may be seated. Thank you. Please pardon me to Mr. Chairman, sir, and other panelists to take the #1 security officer when we talk at the state level and doing greatly well, looking very smart like the security officer he is. May we respectfully ask that the #1 security officer, the police commissioner, please be on his feet as we do his citation. Our distinguished guest is a senior officer of the Nigeria Police Force and the Commissioner of Police, Edo State Command, with over 3 decades of operational and administrative experience in law enforcement. A seasoned law enforcement officer with over 3 decades of distinguished service in the Nigeria Police Force, a native of Ida local government area of Kogi State. He holds a BSc in psychology, an MSc in organizational psychology, a diploma in police science, and an MSc in security and strategic studies. His career is in the Nigeria Police Force spans. I beg your pardon. His career in the Nigerian Police Force spans several strategic formations, including operations, investigations, intelligence coordination, and command leadership across multiple states of the Federation. Our commissioner is properly schooled. I thought we were going to clap loud when we were rolling his scholarship CV. It's a very tall scholarship CV. He has served in various capacities, including Deputy Commissioner of Police in charge of Interpol operations, Pulse Authority Police Command in Port Harcourt, and a several area command in Ogun and Lagos states. Prior to his current appointment, he also served as the force headquarters at the Force Headquarters Abuja, where he held command responsibilities in the Mounted Troop and Force Equitation Office. Widely regarded for his professionalism, leadership, and commitment to community-based policing, he continues to champion effective policing, public safety, and stakeholders' collaboration in the maintenance of law and order. In April of 2025, precisely last year, he was appointed Commissioner of Police, Edo State Command, where he now leads policing operations and coordinates security strategy for the state with a mandate to strengthen public safety, enhance operational effectiveness, and improve community police relations. We are privileged, we are well secure. So please make welcome the CP Edo State, CP Monday Agonita, with a loud clap of applause. These are particularly for responsibilities that are known for nearly liver fields. Please, a round of applause again for Mr. Chairman and the panelists. Mr. Chairman, permit me to add, while I have thanked this young man behind the curtain, let's declare when somebody is doing great, even a public accolade at times inspires the person to do more. All of the CVs we have been reading so far, since the inception till now, have been researched, compiled, and put together with sterling grammar and sequence by the one and only Publicity Secretary of the Lion Bar, Joseph Brian. Please put your hands together for him. Very great job. Ladies and gentlemen, I'm proud of him as one of my teammates at this chapter. Microphone.
Thank you so much. The Honorable Secretary to the State Government, please, we are standing on all the protocols that were established from the beginning of the day. I want to sincerely explain my position as the chairman of the session, because the person who was supposed to chair this session is no other person than Omondowa, Senior Advocate of Nigeria. On Monday, I think at about 9 a.m., I got a phone call from him, and he explained his predicament to me, told me that he was to chair this session, but that he had a national assignment. He explained the national assignment, I can't remember what kind of assignment, but that he would be at Abuja today, and they wanted me to step in. He said they had told the chairman of the Law Committee, but the chairman said he was afraid to tell me to chair the session, so he decided to do so himself. And I told him that was okay, because I have a long-standing relationship with the Benin Advocate running about 40 years now. So I counted it a pleasure and a privilege to hold forth for him. And also I saw the array of participants in this session, heavyweights. I said, well, if they needed somebody to strengthen the panel, I will step in. And I've always told the bar that I am indebted to the bar. I came from the bar to the bench. And whatever services I called upon to render to the bar, I would do it diligently, wholeheartedly, and happily. So immediately I was told, even I thought I should have told me, I would have stepped in happily. That's some of our joy, that we came from the bar to the bench, and so whatever the bar is doing, we are glad to participate. Those that's to explain why I'm chairing the session. I want to commend the NBA, the Lion Bar, for their consistency in holding very robust law weeks from year to year. Every law week, they do success. And from what I've seen, if you are taking it in each higher, I wasn't here yesterday physically, but I was with you online. Since on Sunday, people have been streaming, and you are still streaming today. And that's the way things should be. So that even people who cannot come physically, wherever they are, they can be participating. So I commend your initiative, and I pray that God will help you to sustain it. We go straight to the presentation. Now I will also clarify, the learned Vice Chancellor was to present, but they forwarded the paper to me, and I saw very, very pleasantly that the paper is a joint presentation. Professor Nelson, you put the input. Now, my challenge is that these are thoroughbred academicians and legal scholars in their own right. I've seen them in court. Professor Nelson has appeared before me, Dr. himself has appeared before me. So we have a very strong presentation here. I've gone through the paper. I don't know whether they have sent it to some of you. It's a very strong paper. You will tell the Vice Chancellor that tonight I'm going to upload it to the net. You know, I run a website online, Nigerian Law Group, so I will be putting it up tonight because it's strong enough to go online, and I will do that tonight. So it's not just that he came to stand in for Professor Dr. Doba Omorege. If you see the paper, you see that he's a co-presenter. And so he's speaking in his own right too. These are professors of law. When the professor is talking, I think we are going to be listening. So they will be speaking, or two of them will be speaking actually, on the subject law, power, and policy, shaping Nigeria's future through legal and institutional reforms. And these eminent personalities will be discussing it. And I'm so happy, particularly for those of them who are here, the Honorable Secretary to the State Government. That must be a huge sacrifice on your part. When I saw these people, I said they were all sent representatives, but I'm pleasantly surprised and very, very happy that even the CPs here himself, the SSGs here himself, that is wonderful. Even the Chief Onyafi, you are standing for the Speaker. The Speaker must be in the trenches. The battle to get the battle to come back, and then after the battle to come back, and try to continue the battle outside. So I will appreciate it. My brother, you tell him that I congratulate him for the consensus. One of the few people that got consensus ticket. But I know that the getting consensus must have gone through here. But that notwithstanding, tell him that I appreciate him sending you. You are also a seasoned practitioner. You have appeared before me several times. So you are also in your own rights, you are strong enough to hold for. So they will be discussing this erudite paper. I won't waste much time. I want the eminent professor to go and make his presentation. The rules are settled. 20 minutes for the presenter. And then the discussant will not exceed 10 minutes. If you want extension of time, you must show exceptional reasons for extension of time. But let's try our best. I know people know this is your paper. You'll be able to speak to some areas of the paper. So you can take the floor.
My Lord, the Chairman of Session, distinguished members of the Great Lion Bar, special gentlemen, because there's no lady here, I stand on the existing protocol. The paper is Law, Power, Policy, Shaping Nigeria's Future Through Legal and Institutional Reforms. My Lord, the time is quite hard, but we'll see how we can manage to navigate through it. Okay, so while they are getting the IT equipment, I'll just say we appreciate the privilege given to us by the Lion Bar to add value to the legal profession, and especially be given this area of the discussion. As we progress, we see why this is very important. Our paper discusses law and power and how the interface is engaged to develop policies and implement them. Now we say law and power shape each other. Law and power shape each other, which is understandable. The law is there, very stiff. The power to enforce the law and implement the law and enforce the law. Then the policies to ensure that the implementation and enforcement runs smoothly. Now we say legal reforms will balance power, institutions, and justice, because law cannot be static. Law is made for man and not man for law. Now, to make it effective, you have to present it in a level environment that can allow the form of a law. So the law, that the law and power balance themselves through the reforms. Now, we say that Nigerian law is positive and natural law traditions. Of course, in the forum of lawyers, I don't need to start explaining what the positivism and natural law schools are talking about. So, we say the Constitution provides rules for exercising power. It is the Constitution, the ground that says this is the way you must go in implementing the law or in implementing rules. Now, these institutions support the rule of law because the rule of law is sacrosanct. You cannot change it. But the implementation must follow due protocol. So we say policies should operate within constitutional limits. Whatever law you are playing as an institutional head or as an institution, you must go through that within the ambit of what the law says. Now we look at law and power. Thank you, Mr. Chairman. I appreciate the constitution. We say law and power is a perennial dance. You know, the interface between law and power are processes that are very important to the smooth running of society. But sometimes there might be conflict where parties or institutions enforcing the law do it overzealously so that they tend to go beyond what the law says, as we see, as we progress. So we say colonial law was founded largely on force, not consent. You know, the first time Western tradition in law and governance was introduced into Nigeria was through the colonial system of governance. And you agree with me that they forced the system on Nigeria. Well, the entity that was there before the Nigeria as a country, it was forced on the people, not by consent. You agree with me when we recall the race to leaking and the Benin episode. So you see that the people didn't sit down to okay, let's negotiate how law will be introduced into Nigeria. So of course the 1914 amalgamation lacked popular approval because the amalgamation happened. Most of us, or in fact, I don't think there's anybody who was born by 1914 yet. But our forefathers who were there were not consulted. Maybe they got picked 2 or 3 or 4 persons and provided them with maybe snuff or gin, and those ones said, yes, we agree what we're saying. So there was no consent as to, okay, this is how we should be governed. So there was no popular approval. Now, these origins continue to affect governance even up to the present day, as we will see. Governance has been one-sided, I would say. With apology to our SSD, governance should be a two-way traffic. The system, the state should work with the society to achieve good governance. Okay, so we trace it from the 19th, that's proper governance or constitutional governance, starting from the independence of Nigeria, the 1960 Constitution, to establish democratic institutions, as we will see, the legislature, the other institutions, the police, all those institutions that were autonomous, they were established by the 1960 Constitution. Then, with their inadequacies, the 1963 Constitution now solidified the provisions on democratic institutions and governance. Now, from what we have seen, we say politics also undermine constitutional ideals. Politics often because persons are appointed or elected to hold office, to head institutions, and they are supposed to enforce rules and policies in accordance with constitutional provisions, but sometimes bounds or overstepped. So politics also undermine constitutional things. And then which safeguards contributed to the 1966 coup. We agree with you that it was a declaration of state of emergency. That was the first time state of emergency was declared in Nigeria. And that led to the sequence of events that led to the coup of 1966. So when we look at the key rule of law challenges, we identify executive overreach either as a president or a governor or any other executive institution. They are elected or appointed to run the system, to run governance in accordance with what the Constitution says. But sometimes, maybe out of overzealousness or other primordial considerations, they overstay their bounds, leading to confusion. And that's why the executive overreach is a challenge to rule of law implementation. Then judicial independence remains fragile. You agree with me that? My Lord, the judiciary is doing fantastic job in Nigeria. But the challenge we have is the legality of it. So when we look at executive overreach, judicial weakness, and nonsense actors. But we say, let's have this at the back of our mind. The bar must, the bar remain central reform. Therefore, they must take up their position, their role as performance of the system, the bar bench, because they are the ones who hold back in what the law says. Now, we look at the executive overreach. Then we said the executive overreach has roots in the First Republic. It didn't just start now. I mentioned the 1966 coup and what led to it, the declaration of state of emergency in the western region of Nigeria. The western region arose from political conflict between government and premier someone like each other. So when the issue arose, it was purely political. But because it was a pretense as governance according to the constitution, it led to imbalance. Now the Prime Minister, declared the state of emergency in Western region, placing it under federal control. Whereas the region was supposed to be self-government. Now the declaration now toppled the governance that was there, the constitutional governance that was there, leading to institutional imbalance. Now let's just demonstrate how constitutional powers should be used for partisan political ends. The Prime Minister was acting on the basis that he was implementing or enforcing what the Constitution says. But because of the executive overreach, that led to problems. Now the result of instability and violence contributed to the conditions that eventually led to the January 15, 1966 coup. Now the military coup, we don't need to review what happened, but we know that it was the root of what eventually led to even the Nigerian Civil War. Okay, so the Baliwa Conference actually created two very pathways for abuse of power. On one hand, they were saying they were doing what the Constitution said they should do. But unfortunately, because of the overreach, they created pathways for abuse of power through partisan use of emergency powers, then military intervention in government. Now, both pathways have continued to shape the Nigerian political experience up to the present day. Now, the biggest case of emergency and successive military coup in 1966, 75, 83, 85, of course, the 1966 75, Madala Mohammed, 83, Barry, 85, IBB, and 93, Abacha, weakened constitutional governance. Because at the beginning of each military intervention, what they do is to dispense with the constitutional provisions. And how can you now, you are living in the house starting with the foundation. You now come in put a foundation. Can the house stand? No. That is the challenge we have up to the present day. Now, military against frequently suspended or diluted constitutional supremacy because they find that they do need to, they change it or adjust it to serve their personal ends. Now, executive lawlessness and corruption continues to reinforce one another. That is the big challenge we have. Now, we look at proposals for reforms, including, and of course, it is not exhaustive, but we just identify some that stronger legislative and judicial oversight need to be put in place. Then, independent institutions. All institutions, the police, the ICPC, the DSS, the judge, all must work according to what the Constitution says, because the law is the director of what should be done. So we need to strengthen, as a country, strengthen the independence of institutions. Particularly those that they find like INEC, because we are going to have the INEC and the eye of the storm very soon, and they need to be strengthened so that they can do their work according to what the Constitution says and the subsidiary laws like the Electoral Act. Now, legal text and constitutional amendments are important tools of reform. Textual reforms alone cannot succeed where a culture of impunity persists. Even if we do our Constitution, amendment of the Constitution 20 times in a year, if we do not strengthen institutions, then we are just playing, right? Because the American Constitution does not have more than, I think, about 22 amendments. Just one small booklet that is, because the people decided that they want a working Constitution, and that is working for them. But we have carried out several amendments to our Constitution, but we seem to be taking one step forward, 2 steps back. But we must strengthen institutions of society. Now, how do we achieve some of this? Through public interest litigation. There be a true support litigation that challenges oppressive or outdated practices. We can't get tired of doing this because it is very fundamental to a good society. Now, strategic cases can expose systemic failures and stimulate reforms. Let me just digest a bit. Mr. Chairman, years back, 2 years after the fall of apartheid, the Constitution of the Republic of South Africa provided that the state was providing free health to the citizens, free health, medical services, free housing, free so many things. Not like our own that is not just self-well, see other controllers, whether it is just self or not. But in the own, it was very clear that it was self. A few students of the University of Cape Town under the law clinic program organized themselves and sued the government, the national government of South Africa. The case went from the High Court to the Supreme Court of Appeal, which is their court of appeal, like our own court of appeal, and to the Constitutional Court, which is the Supreme Court. And it was decided that the state owes anybody who is a citizen of South Africa and anybody who is legally allowed into South Africa the responsibility to provide for this. In as much as we can say that the fallout will be both South Africa and South Africa, the failure of institutional governance because of maybe the paucity of resources against the increasing demand, because the rule is that if you come into South Africa, you stay 5 years, you are given PR, you are qualified to access all this. So we need to also, in our own time, ensure that we support the litigation that challenges oppressive and outdated practice. We will start implementing to help to formulate new policies that will also help to change the law. Now, strategic cases can expose systemic failures and stimulate reforms. Class action can empower communities to seek institutional accountability, and that's where the bar must play that role. Because the citizenry might be shy of enforcing their right, but when you brought them as members of the bar who are very enlightened, the bench cannot be the bench is supposed to be, of course, the bench should not intervene in governance, but the bench should interpret laws issues are brought before them. So it is the bar that must engage the bench through bringing issues before the bench for them to decide one way or the other. And this is the challenge to the Lion Bar that has always been in the forefront of the enforcement of fundamental rights. Let it go beyond just basic fundamental rights to other rights that affect the larger society. Now, citizens should be trained to participate in policy reviews and legislative processes through petitions, memoranda, and proposed bills. If we propose and they don't enact any law, by the time we propose 20 or 50 in a year, there's no way 10 or 15 or 5 will not get the positive attention of government. Okay, so advocacy partnerships is very important. Strong institutions are built to legal compliance and ethical standards. Without go playing by the rules, governance cannot work. But when we go do it through compliance with ethical standards, then the system stands to benefit. So in this case, the bar should promote this professional ethics and integrity, judicial accountability, anti-corruption initiatives, collaboration with civil society, and all others, including policy. This is important. Policy, electoral systems, public procurement, prison administration. Now, if we take policy, the police is guarded by the Constitution and the Police Act. Now, they should enforce it methodically and religiously to ensure that rights are not infringed upon, and that even somebody who doesn't have a godfather should enjoy the possession of the law and the possession of society. Now, electoral systems is what we are facing now, the challenges of ensuring a strong electoral system. It behoves the bar and the bench to play this important, be in the forefront of the development. It's not only for them. The other institutions, other state institutions will also play their role. The public procurement, of course, we know that public procurement is important to good governance. Then, prison administration, ensuring that the law guides those who are enforcing the administration of criminal justice and all of that. Now, judicial independence, and that's very important. Judicial independence means freedom from external influence in decision making. A judicial officer should not be doing his work. The judiciary should be protected fully for the system to work. So now, and without judicial independence, justice is dispensed according to the favor of fear rather than law. That's why the judiciary must be protected to dispense justice effectively. Now, Nigeria's history reveals president interference with the judiciary from colonial time to the present day. And anybody who says that is not the case might be economical with the truth. We know that the challenge is there, but we must protect our institutions to do this strong. Now, judicial interference has evolved from the cigar of court orders. Initially from the state, I believe in the state and this judge that under this rule that they should allow the judiciary to take decisions religiously and then enforce it or implement whatever comes out as a policy or a decision of the court. Obeying court order is very important and circumstances there. Now, political pressure, corruption, and intimidation continues to threaten the independence of the judiciary. We need a judiciary that is very independent. We need it because if the power of the state, the judiciary is eroded, it will cascade to even the bar and all of that echelon of society. So we must protect them with all resources at our disposal. Now, recent years have witnessed multiple forms of judicial interference. Nobody can dispute that. Examples include disregard of court orders and controversial cases of removal of judicial officers. This experience is still very fresh in our memory. The experience of Justice Onomi and some others. That was the greatest aberration in violation of rights. Apart from the personal rights, it was also a violation of institutional rights of those judicial officers, because they represent institutions, not as individuals. So, electoral identification has related significant controversy as well. Judicial misconduct and political relationships with politically exposed persons undermine public confidence. What we're saying here is, when, of course, we know what a politically exposed person is. Then also, we know them. Persons who have been appointed into public office are people, those are the politically exposed persons. There should be a sort of form of insulation from, especially when they occupy those offices, there should be a form of insulation of the judiciary from what they do as heads of institutions or administrators of state institutions. The situation where a judge is like what's happening in some areas of Nigeria, let me not do that, but at least, for example, FCT, what's happening there, we know it shouldn't be that way. There should be a form of insulation from what the judicial officer is doing within that time he's holding that office. It should be insulated from any interference, because even if it was done in good faith, people are bound to misinterpret it. Now, we need to strengthen our judiciary by ensuring that judicial independence is essential to Nigeria. And if we say it is essential, then we must enforce it. We must guard against it as we approach the 2027 elections. That's very important. Now, recent years have witnessed multiple forms of judicial interference. Examples include, okay, so the next one, please. Okay, so now we have discussed the malice. We have discussed the issues that present challenges to law, governance, public governance. So look at the proposals we have. There are a lot of issues, a lot of areas that we touch with the but we just itemize a few as proposed reforms. So there are three major drivers of judicial interference are the appointment process. The appointment, we identified the appointment process, the financial control, and systemic corruption. For appointment process, we all know that we could do it better in appointing our judicial officers. It's okay, the work we have in the book, we have improvement. Then financial control, the judiciary represents one of the three arms of government. There's no reason why there should be interference in how the judiciary is run. It is one distinct arm. The executive is another distinct arm. The legislature is another distinct arm. The three should run independent of the other, but cooperating together for synergy to ensure good governance. Now, judicial appointment should be transparent, merit-based, and legislative influence. Greater autonomy should be granted to the NGC in the appointment process. The full financial autonomy and adequate funding are essential for judicial independence. And that, I believe, that has been legislated for. But it appears not to be working. I don't know why we have that challenge. It's not working, and maybe as stakeholders we must also look into how we can do it better. Now, structural reforms must be complemented by ethical orientation, accountability, and sanction for misconduct. When there is sanction for misconduct, it signposts the need for everybody to fall into line to ensure that things are done the right way. Now, the NBA and civil society have a critical role in promoting integrity within the judiciary. The judiciary might not do it alone. In fact, the judiciary is very expected to do it. It is the NBA and civil society that should do it. Because some of us also eventually gravitated into the judiciary. So also, the law is a critical example. And you see that when we move down, they are better prepared to do the job. So if we know that this is our home, the judiciary is our home, we must be in the forefront of playing to safeguard what happens in the judiciary. And I believe the Lion Guard will do it, but they have been doing it in the past. Okay, so we will now look at the non-state actors. I don't know how long that is. For non-state actors, the rights of non-state actors reflect weakness in the rule of law and state institutions. It's not because things are not working that people become reactionary, like the Niger Delta question. So because things were not working, the people whose resources, whose land, their resources are suffering, pollution of water and all that. Meanwhile, they took them to Abuja to do what belongs. Is it 3 million man march or 4 million man? So they saw the skyscrapers and the good roads and all that. So the resources that is invested from other accounts is now used to do. That's how the Niger Delta crisis started. So the right of non-state, because the state or the system is malfunctioning, a malfunctioning system will result in reactionaries like the non-state actors. So in Nigeria, non-state actors is satisfied in the use of de facto power, where governments make decisions. It is happening everywhere. Even in the Northeast, it was a vacuum created by the high level of poverty that gave rise to, because that was the ground that the initial promoters of Boko Haram said it was because the government was not taking care of them and all that. Whether they were right or wrong, that was the beginning. Now, the Niger Delta presidency emerged from the dispute over resource control through federalism and socio-economic dignity. Some militant groups have continued to influence governance and public policy beyond the amnesty program. Even after the amnesty program, you will see that they are still playing roles. Our pipelines are being guarded by the promoters of the Niger Delta crisis, right? So they are now playing a role because there was vacuum created by the ineffectiveness of state institutions. Now, the IPOB and other separatist movements reflect long-standing concerns about political exclusion and marginalization. If the state addresses all these problems, of course, they might not have any reason, no issues to say, okay, they want to be reactionary. Now, the activities of non-state actors reveal the gap between constitutional ideas and political realities. Okay, so the treatment of non-Africans is contrasted with that of some terrorists and other armed groups in northern Nigeria. That is the thing. When sets of laws or 2 sets of laws instead of 1 is being implemented in the state, people tend to have information about the effectiveness of the state. People who were involved in terrorist activities were arrested, passed through the trial system, and given a risk handshake of maybe 5 years. But the other one doing the same thing, who feels that his actions are justified, is given license. So this tend to bring reactionary elements in the system. Now, perceived disparities in prosecution, sentencing, and reintegration policies raise concerns about equal application of the law. Because the law is not supposed to be more than one. It's not one state of law. As law, not particular statute, but the law as a holistic, represented by the Constitution, is one. You don't have 2 constitutions, one for the South, one for the North, one for the North, one for the South, one for the South. No, it's one Constitution. The 1999 Constitution is the extant Constitution of Nigeria. Therefore, the enforcement and implementation must be uniform for all persons and all areas of Nigeria. Now, these differences have shaped public perception of justice and government policy. The operation of public Sharia law in some northern states has also generated debates about legal uniformity and equality. And we will say the Constitution is the ground called guiding everybody in Nigeria. Now, consistent and impartial application of the law is essential to maintaining public confidence in the legal system. I believe you agree with me on that, right? Okay, so the activities of non-state actors reflect unresolved agreement and disagreement, and I have said, hence, sustainable reform requires broad national consensus and commitment to true federalism. True federalism, we emphasize true federalism. Constitutional reform must be driven by active participation of citizens across the country. There is no ownership of governance, no particular area owns it, right? It's not owned by the West, it's not owned by the South. It is a holistic ownership. by all Nigerians as stakeholders. Now, constitutional reform must be driven by active participation of the citizens across the country. Double standard in the application of law can only be addressed through political will and public accountability. Political will, very important. Without political will, we will be deceiving ourselves. If you see A, call it A. You see B, call it B, no matter whose ask is done. Now, achieving meaningful reform requires a whole of society approach. Everybody is a stakeholder, and we must all participate in ensuring that what we are saying is doable. Because it's doable, right? Okay, so can we? So final word of the role of the representative class judiciary. You know, we've been saying this is your work, this is our work. I'm happy that my Lord is here. I'm a very active member of the judiciary, and who has the spirit, with the benefit of hindsight, having been on this side of the divide. So this is our work. We must lay down to ensure that things work for a better society. Lastly, legal and institutional reform depend on the collective action of the people. Because the people own governance. It is our governance, not an individual. Anybody who is there is just there as a trustee of governance, right? As a trustee of the people. Because everybody cannot be in charge of governance. So those who are appointed are trustees of our collective ownership of governance. So the more public institutions are captured by political interests, the greater the need for an active and informed citizenry. We cannot say, okay, because things are not working well, let's hold our hands and let's not do anything. No. We must take ownership of our government and fight to ensure that we protect it. Because we do not have any other country except Nigeria. The Nigerians who said, okay, they went to Japan, they went to places, you can see what is happening now. They are being told to go back. So we should take ownership of our government and ensure that things work the right way. The FDA will serve as an ally of the people in promoting accountability and constitutional governance. Lion Bar has always been the forefront. And I'm placing the chair at the last year to say the challenge is here. All of us must get up to do it, and we have to do it, right? Okay, so the judiciary should adopt more proactive approach to interpreting the law in line with the legitimate aspirations of the society. Especially involvement in judicial activity will be helpful here, where there are gaps to cover it. You don't say, okay, this was not part of what the law says. So judicial activity will help in addressing societal. Now, the judges and lawyers occupy a big position of public trust and must lead the demand for reform. That's obvious. It cannot be disputed. The bottom-up approach is essential to building a new and reformed legal order. It's very important, starting from the base, working upward. By the time we go our things right at the lower level, those that the upper echelon of society will now say, okay, this is what I'm doing, they're listening to trying, they're doing the right thing. So everybody will be encouraged or forced or coerced into doing the right thing. And when all of us are doing the right thing, we'll be able to achieve a good, right, and egalitarian society. Thank you very much.
It is a standing applause, a more standing applause. Very distinguished and eminent professor of law. You know, I explained at the beginning, I said Professor Ejoba Morigi is not the sole presenter. I hope I said so. That's the paper I have two presenters, and Professor Nelson Ojukwu is the second presenter, and you can see how effortlessly he made presentation. I don't envy the panel of the substance, because when two eminent professors of law combine to produce a paper, you can see how tight the paper is. It's both jurisprudential, judicial, practical, pragmatic, it's everything loaded together. So, but I can see the people are eminently qualified. The panelists are eminently qualified. Maybe I should summarize maybe 6 or 5 points so that to refresh their memories, even to refresh the memory of my very revered Sikh who has walked in, and my learned brother, they are here. The learned professor started with an excursion from the colonial era, and it's so enlightening. He told us that there was no consensus that Nigeria was created, was not by anybody's agreement, that the British, the colonialists, took Nigeria by force. A historian once said something. He said, God did not create Nigeria, that is the British that created Nigeria. A historian says so. And that's what the learned professor has said. That it was by force, not without our consent. And even the 1914 amalgamation was also without our consent. Because the paper is talking about law, power, and policy. So it was a power play by the British colonialists, even before independence. And then he told us that even after independence, when we now took over and we now had power, that there was now a power play again by government, the executive arm, state actors, and I'm very happy they talked about non-state actors, but most of the people here are state actors, so they will tell us, because he traced me that even the state actors, particularly the executive arm of government, emasculated the other arms of government, even after independence. The overreaching, executive overreach, that's what they call it. And talked about declaration of state of emergency. And we have seen it even under even this current dispensation, the political dispensation, state of emergency. Pointed out River State, pointed out Plateau State, even there was even at Ekiti State. All these are executive overreach, where you overthrow the whole House of Assembly, and then they begin. He mentioned all this type of power play, and they advocated a synergy between the bar and the bench, that we are all here. And let them thank you so much for coming to support me. So you not say I'm the only one that came here. Thank you so much. So the bench and the bar, he advocated a synergy between the bench and the bar to actually protect and to preserve the rule of law. Then he emphasized the independence of the judiciary. Thank God the speaker sent somebody here. We jubilated last year when the law was passed. There's actually a bill that granted the judiciary financial autonomy. And we jubilated and celebrated it last year. And they gave us huge budgets. That also billions were released to the judiciary last year. Surprise. So they talk about independence. No judiciary can be independent if we keep on going to government house cap in hand. And my God, the Honorable Chief Judge has vowed and is not ready to beg anybody for anything. But we are ready to cooperate. And we are ready to move the state forward. But they should release what belongs to the judiciary because the whole system will not collapse. I think the SSD understand what we're saying. And the man from the House of Assembly. So when we talk about independence of it, there can be no independence without financial autonomy. And it's a situation whereby the executive arm will boldly, yet amiss, cut off budgets to emasculate one arm of government. That will not help the system at all. So today, we want our the House of Assembly people and just SLG, we will address this issue of autonomy and independence from the angle of what has happened to our budget, how we can actually be restored. Yes. So then he talked about the emergence of non-state actors. They are not here. Boko Haram, insurgents in the north, Niger Delta militants, Egbesu, and other type of people. But incidentally, in those states, we have non-state actors, social police. There are active non-state actors operating now in those states, almost running a parallel government. Somebody calls himself the street government. Some of you will know that. There are people on the streets now running parallel government, but sometimes when I'm driving sometimes, I don't know the difference now between the Nigerian police and some people who wear some kind of funny uniform on the streets. And then these are non-state actors. And then in fact, the non-state actors sometimes appear stronger. We are going to election, now when we go to election, they will tell policemen not to enter the polling booths. But there will be talks, armed talks, strong talks on ground to take away ballot boxes. So these are the situations we find ourselves. And this paper has pointed out is the power play we're seeing. But at last, there's good news that there will be a cooperation between the bench and the bar. So this is a summary of what has been presented. I will want the blended secretary to the state government who actually represent the executive arm, which appears to be the strongest arm of the three, to kick-start the discussions. You have 10 minutes. So try to address it with courage and with sincerity.
Thank you very much, Mr. Chairman of Session, my Lord. And I would beg to stand on whatever protocol has been established. I must confess that this has, it seemed like an ambush. And I'm not very sure that I have the requisite courage and sincerity that my Lord has demanded from me, but I will do my best in addressing some of the questions that he has raised. But before I go into some of those specific questions, I would address the subject of the panel by touching on some key areas that the lead discussant or the lead speaker has already gone through. In fact, when the invitation was sent to me, I had a lot I was dealing with. We just finished the primaries and so many other government business. Our executive ESCO meeting will be coming up tomorrow. We're dealing with a lot of memos. So I skimmed through and I said I would like to be here in order to, first of all, appreciate the effort of the Lion Bar, who have been doing wonderfully well and they've been following up with us on so many things. And also to add the voice of the executive to this discussion. I think I will just touch on areas that I believe the paper may not have addressed. I do not want to go into all the issues that have been addressed. We are talking of law, power, and policy, legal institutional reforms. I want to start by exposing the very foundation of the need for law, power, and policy in society. And I will take us back to the very beginning, to the very idea of the social contract. Before now, we know that societies were basically autonomous and independent, or humans were living in a state of nature, like Thomas Hobbes would say. It became necessary as society became complex that people come together to donate some of their rights and liberties for a central authority to regulate their affairs and also protect them. So in doing that, they forego some of their rights and allow that central authority. With time, that central authority has to be imbued with the necessary powers and also the necessary authority and legitimacy to exercise those powers. And of course, as societies became complex, it became necessary to check the excesses of some of these powers, and then systems became more refined from authoritarianism, monarchy, and then we now have democracy, which is basically the governance by expressing the will of the people. And for a state to exercise authority, it has I want to address something that the lead speaker just said when it comes to non-state actors. Why do non-state actors emerge? It's because there is a missing element in the way a state exercises authority, especially in our country, like Nigeria. For a state to have that authority to exert its will on the people, it has to have monopoly of violence. So all the instrumentalities of violence has to be with the state, not with the citizens. So where citizens now have access to the instrumentalities of violence, it's symptomatic of a failed system or a failed state or a glitch in the system that is supposed to run a successful state. So what we are seeing now are the proliferation of non-state actors having access to all instrumentalities of violence. We can clearly say that there is actually a democratization of violence as it is, which is very symptomatic of the failure of the state itself to control that sovereignty, that ability to be sovereign authority in a geographical location and exact its will. And there are many reasons for this. I think the speaker already listed some of them, which is when there is no justice, for instance, people do not feel satisfied, then people will want to look for other means to exact its will. When the system for addressing wrong or injustice is abused, or the confidence in that system is eroded, then people will seek other means. And that is the clear case of what we have in Nigeria, where non-state actors are now springing up everywhere because they do not have faith and confidence in the ability or even sincerity of the Nigerian state to address their problem. Now, when we say the abuse of power, most times what comes to mind is executive overreach, right? And that was mentioned in the paper. But it is, I like to see the idea of the abuse of power as pervasive and something that permeates all the three arms of government. So we do not just have executive overreach, we also have legislative overreach, and we have judicial overreach, if I dare say. So as someone who has had something to do with all the three arms of government, I have a direct experience of this. You know, I have practiced, and I have also worked very closely for many years, over a decade, in the National Assembly, closely involved in policy formulation as well as lawmaking and providing advisory and consultation services. I have seen that. And now I'm in the executive, so I can fairly speak of these elements of overreach in all the three arms of government. But of course, the star boy is always the executive overreach. And that is because the nature of executive power itself demands action and movement and high mobility, unlike the power that is residual within the legislature, which is to basically make law, or the judiciary, which is to interpret those laws or adjudicate whenever there are conflicts on the implementation or interpretation of those laws. So I want our analysis and outlook on all this excessive use of power to be more broad-minded, to go beyond just executive overreach and cover other areas as well. Separation of power, I would like to touch on that, which is a fundamental principle of the rule of law, as well as democracy as we have now. And it's something that we continue to refine. As a democracy, we definitely cannot compare ourselves with countries that have practiced this for years, over 2 centuries. But we are getting there. So there are challenges, of course, with separation of power, but the kind of judicial reforms, legal reforms, and institutional reforms we are seeing is bringing about improvement in that aspect. But one misconception that I would like to also clarify is that separation of power is not an absolute term. There is no way we can have absolute separation of powers. What I mean is watertight separation of power. There will always be collaboration, cooperation, and necessary synergy between the executive, legislature, and the judiciary for things to move smoothly. It is when every arm regards itself as totally separate and independent of the other, it will generate a lot of friction and a lot of tension. And we see this sometimes in the system. But if there is cooperation and synergy, then a lot is done because it is actually one system with three parts. Governance is one. For the common man in the street who wants the basic necessities of life, housing, proper health care, food, and all that, I'm not sure that they really understand the intricacies of the separation of power. So it is basically for we who are practitioners of power in the system that this concept is very useful to us. But for the common man, they just see governments, and they want government to deliver these dividends. They do not care whether it comes from the judiciary, the legislature, or the executive. They regard it as one government. So it is for governance to get to the people, and for governance to be effective, there has to be a way where the three arms of the government, we have to collaborate and synergize more. Pronouncement from the Supreme Court. We could not even do it through constitutional review. And even that is even still controversial now, because there is an argument as to whether the pronouncement of the court can alter the provision of the Constitution. So there is still the argument of the provision of the Constitution. So there is still the argument that those provisions of the Constitution still have to be amended before we can say we have full local government autonomy. So these are the challenges. At the end of the day, we go through this ritual every year, spend 8 to 10 billion in this whole reform process, but nothing comes out of it. So these are questions we have to ask ourselves. You know, whether we are very willing and serious about the reform that we say we want to carry out. Then, finally, I will just touch on institutional reforms. There is the legal, there is the institutional reform. Very important to embark on some of these institutional reforms so that they give the vehicle, the necessary vehicle to implement some of the legal reforms that we are seeing. And some of the institutional reforms that we are anticipating now is the decentralization of the police force, and I'm happy that the Commissioner of Police is here. We're talking of insecurity in the country. It has become practically impossible to police the Nigerian state with the system that is currently in operation, the Nigerian police. It's practically impossible. That the fact that it is the current IG of police has set up a committee to see how we can, the idea of state police can be operationalized. We were already doing that in our own way, but we didn't have necessary backing by law. Of course, state assemblies were able to pass their law to establish some sort of security apparatus system, like the Edo State Security Corps, and I believe that's what my lordship was referring to. We have that in operation, backed by law. But there is a limit to what they can do because they still have to operate under the Nigerian police. And there is a limit to the kind of weapons they can use. So this is some of the challenges, the institutional challenges that we need to take place. But then through federalism, fiscal federalism is also very important for us to get things right as a country. Now we are talking of proliferation of non-state actors. We have in the southeast IPOB, we have in the northern region, all the terrorist organizations from Boko Haram and others. All these are part of the inadequacy of the Nigerian constitution as we have to address the complexity of the Nigerian state as it is. And until we tinker with that constitution, in order to be able to have a true federal system that will express the will and aspiration of all Nigeria's federating units, then a lot of these units will continue to agitate. And these agitations will find expression in, like someone said, when you fail to make peaceful resolution impossible, then people ensure that violent revolution becomes inevitable. That is what we are seeing, and that is an area of reform that we must tackle. Finally, I want to address a society heading. Where is society heading? Especially in the view of the digital society that we now find ourselves. You know, it's a digital currency is taking over. All these, we have implications for society. According to studies by World Economic Forum, in another 5 to 6 years, artificial intelligence will be wiping out about 70 to 80% of the professions and jobs that we currently have. And even our legal profession is at risk. Not just the legal profession, the medical profession. But then, the human element will always be relevant. And as lawyers, we are social engineers. We are to determine how society is to regulate itself and function within the parameters of law. Artificial intelligence is taking us to, and how do we, engage in some sort of legal and judicial activism to prepare our society for that. Of course, what we have now is just a law that talks about data protection and privacy, but it needs to go and now having a law that regulates artificial intelligence, and this is something that we need to do. And I also call on the bar to take up this challenge and organize programs for this and other advocacy. Now to the big elephant in the room, the relationship between the judiciary and the executive. Like I mentioned, this is a relationship that should be smooth, should be cooperative, and should be synergistic. Unfortunately, we do find tensions here and there. Now, I am not aware that there is any sort of tension between the executive and the judiciary. I'm not aware. We have continued to work very smoothly together, and wherever there are misunderstandings, there is a way that is channeled and it is clarified. The fact that there was a budget cut, I am not sure that it should be interpreted to mean that there is a problem between the executive and the judiciary. I think it is basically an administrative issue that has to do with the office of the Commissioner for Budget or the Office of the Accountant General. This matter came up before and we addressed it. The thing is, envelopes for budget, we need to understand, is always different from what is finally passed or what is finally appropriated by the House of Assembly. Thank God the Speaker is here, everybody represented, they can address that. Ministries are given envelope and they bring envelope. A ministry can say, our capital proposal for this year is going to be 10 billion. But in the end, the Office of the Commissioner for Budget, Accountant General, Commissioner of Finance will sit down and analyze those capital proposals vis-a-vis the projected revenue of the state, and then bring those capital proposals in line with those revenues. So everybody experienced the budget cut, not only the judiciary, even the House, the House of Assembly also experienced that, especially when it comes to capital projects. But I am glad that only capital Ministry of Budget, I believe that is what must have happened. So it should not be interpreted to say that it's symptomatic of a sort of rift or code between the executive and the judiciary. Thank you very much.
The Secretary of the State Government has shown that the legal profession is a great profession. Only a lawyer argue like this. And I would recommend the NBA should mark him down as a veritable resource person. I've never interacted with him, but it is clear that he's a scholar in his own right. He's an intellectual in his own right. And so please, when you have programs, as usual, make yourself available. We would like to have a scholar too, like you do. We are scholars, and so we come out. So I'm sure they'll be reaching out to you. We would like to see you feature more and more. We are happy somebody like you to see your friends. So you don't make out the case intellectually. We want to make some announcement before the other discussants.
Thank you, Mr. Chair. With the kind permission of the Chairman of the session, Honorable Justice J.O. Okai came in when the session was on. There is standing round of applause, please. So we have introducing the chairman of the bar. Is our chief host, the Lion Bar, the head lion himself, the radio, the Sipo Esquire, holding it down here for a great week. They put your hands together for the prosperity chairman. And of course, sitting close to him, the head checker. My Lord the chairman, we call out the head checker, the bullion bank, the treasurer, the central bank of the Lion Bar. Please, Obasigi. Now, all those English make me the Mr. Chairman permit me for the colloquial. Please, Joy and Aurelia Obasigi, our head checker, the central bank chairman. Put your hands loud for her. Do a good job for the bar. We also have, please, we run through this one. This is the last practical session. Other activities go on. Tomorrow and next tomorrow. Please, so permit us, Mr. Chairman, we have honored famous that who is the chairman of the Lion Bar, the young wing of the chairman of the Young Lawyers Forum. Please put your hands together for where is it that way? I just stepped out. We have Dede Abino Esquire, past chairman, Maduku Dede, past secretary. We have Pastor Esquire, emeritus chairman. Chiero Fiebo is doing great job. Chiero Fiebo is the welfare, doing very great job since the beginning till now. A resounding round of applause for her, please. We also have Thomas E. Ulefon, our elder at the bar. We have Ojekwa E.T. past chairman, Jonathan Aneroa, Otoye Matilda Esquire, chairman of planning committee. Please, my dear brother, Sayuki, please run.
Thank you so much, Mr. McKinney. With the kind permission of the chairman, may I adopt the already existing protocol. I would like to also recognize the presence of our respected seniors here with us. We have Mr. Pius Idemudia Oyiwo. You are highly welcome, sir. And we also have past chairman Eddie Asilawa here with us. We recognize your presence here. Let's put our hands together for him. Yes, I just noted that Leonard C. K.E. Mosiah just stepped out, but I think if you do also going to recognize his presence, he has been with us all the way from Sunday. In fact, he's one man that always, graces every bar activities. Please, let's put our hands together for him. Please join me with your round of applause as I recognize the presence of Dede Albina, past chairman of the branch. God bless you, sir. May I also recognize the presence of E.T. Ojekwa, past chairman of the branch. Please, let's put our hands together for him. We also have with us Mrs. Violet Olumese, former FIDA chairperson emeritus. God bless you, you're welcome. We also have the presence of Itoha Ekama, the vice chairman of the Benin branch. We have with us our dear sister Osato Wago. Okay, yes, please, you are welcome. Let's put our hands together for her. Distinguished ladies and gentlemen, we have with us, lastly, Mr. Lawson A.Y.E.U. Please, let's put our hands together for him. Right now, I will quickly cede the mic to the chairman of section. Graciously, we are most grateful.
Thank you so much. I think the commissioner of police should be the man on the spot right away. You have a lot to say, sir. 10 minutes.
distinguished ladies and gentlemen, permit me to stand up the existing protocols. Looking at the topic of discussion today, law, power, and policy, and how it affects the Nigeria police, the first thing that comes to my mind is, by the way, I'm excited to be here, surrounded by so many learned and probably I'll be the only one that's not learning here. But don't worry, I'll survive. What comes to my mind, it's exciting to be here anyway because there are lots of things I do in my place of work that has to do with law. I've interacted with many of the members of the Lion Bar, and I think there are issues that I think, if given the opportunity, we would like to talk about. But today, I'm not to talk about all the issues. I'm to talk about probably law, power, policy, and some of the issues that came out from the address we got from the lead speaker. So, what naturally comes to my mind is the issue of community policing. Community policing being a kind of all of society approach to policing. I want to see it that way. Then we have the police duty solicitor scheme. That is a scheme that is working in Edo State, and the Nigeria Police Force is also trying to make it work in other states. Probably not as successfully as it is here in Edo State. But we have the police duty solicitor scheme, which is a scheme that came up with the Force Order 20. Force Order, by the way, is the police administrative orders that are issued occasionally by the Office of the Inspector General of Police. Then, another thing that will come to my mind is the administration of criminal justice law, which is the present administration of criminal justice law. It's very good for accountability of police procedures, and it also works with the police duty solicitor scheme very well. And I think that is one area of our cooperation that, so I understand why that naturally will come to my mind. Then the issue of state police. State police, I have been advocating for community-oriented policing for many years. And state police, I also believe, will help policing in Nigeria, even though Nigeria Police Force initially did not see it as an alternative. But right now, from all indications, everybody agree, and the law is ongoing. We're trying to see if it will pass and how it's going to come up with the constitutional change, so that we will have the centralization of policing in Nigeria. Then, of course, all of this, when I look at, I find a problem of legal framework, and that is why I'm so excited to be here talking about this. There are issues of legal framework all the way. Coming to community policing, there is no serious legal framework. It only has a little mention in the Police Act 2020 as amended, and of course we are quick to make lip service to the fact that we are the philosophy for policing, here is community policing, but how much of community policing do we actually conduct? So the PDSS itself, we have the force orders, when it comes to a good policy, all of these are good policies that I think have problem issues of the legal framework. And this is an area where we can work with the bar bench, the legislature, to see how we can straighten this out. Then, if we need a little courage also, executive, whether legislative, whether political, and I'll give a very good example when it comes to the issue of courtesan in Edo State. When I got to the States in April 2025, I know what courtesan was like in Benin City especially. The very first day I recorded 8 court-related deaths. They were just going around the place shooting as if it was an Indian movie that was going on. And I wonder, how can you run a society like this? And we have government here, we have police, we have the military, we have DSS, we have everything. And we have the landmark, everybody. State actors, non-state actors. Yeah, that's what I meant when I came here in April. And I was told, when I showed concern, I was told that this is nothing. Just 8 deaths, it's nothing. That sometimes it goes as much as 20 per day. My fight kills, and the accounting stores. And when it comes to Christmas, or when it comes to allocation, when it's like 7th July, or something like that, an anniversary. So we went to work in Edo State, especially in Benin City. And a lot of people can see now that courtesan is almost gone from Benin City. Oh, maybe I should say that courtesan is no more in Benin City. Yes, I have the records. Okay. Looking at the executive overreach, you want to call it, or legislative overreach, you want to call it, there was this law, because as police officers, we are trained to enforce the laws. The laws are made by the legislative arm, and then, of course, we learn to understand it and to enforce it. And the law is very courageous law, and I found it difficult that a politician can be behind that kind of law, because it's a law that will probably affect your votes in the next election. But because of the courage, executive courage, legislative courage, they were able to sit down and come up with a law that said if anybody engages in courtesan, the person is liable to imprisonment for life. And if anybody supports courtesan, or anybody harbors a courtesan, the person will be liable for 10 years in prison. And not only that, his property will be demolished and confiscated by the government. Yes, then many issues came up. Legally, people were saying, before you can say someone is a courtesan, he has to be convicted. Before you can say this, and that is where I saw. And when you sit down and say executive overreach, legislative overreach, I say, I think the situation intentionally allows such overreaches if it can be used well in the interest of the public. Like I see it was used well here in Edo State in the interest of the public, and you can see the result. Whether you agree with me or not, courtesan has been dealt a very serious blow, and it is not like it was a year ago. So, and that, if we talk about overreach this way, I want to say, what are the areas where we can overreach our functions? Like they say, okay, ignorance of the law is not an excuse, but I find a big problem when it comes to understanding of the laws. I'm not a lawyer, but at least I should understand the law to be able to enforce it. The same way, ignorance of the law is not an excuse. Who is in the best place to give public enlightenment about the laws? Someone should be able to tell. Sometimes that someone understands the law alone is a preventive measure. But who should do this? And that brings me to some issues that I find here. For instance, the Lion Bar. I discovered, I'm sorry, I'm going to run through because of time schedule. The Lion Bar, I discovered you are busy doing your work, but I noticed from the police angle that we have others, for like this enlightenment I'm talking about. You probably think CSOs should be the ones that should be doing the enlightenment. But the CSOs, the civil society organizations, how much of the law do they understand? Apart from those that have got legal backgrounds or that have got this thing, how much of the law do they understand? So I want you to include this in your advocacy as part of your for letting people understand what the law really is. They are going to see civil society organizations and human rights organizations. Many of them are going out of their reach from what I discovered. They come now to the police station and they claim that they have clients. They write petitions on behalf of clients and they want the petitions to be approved so that they will tell the client. So I don't understand. It is not enough for the Nigerian Bar Association to have lists of lawyers that you can check whether somebody is a lawyer or not. We must protect professionalism. It is not just for it is not just in your interest that other people are coming to do your work and spoil your name and make you look like this. It's not just for that. We have people, especially in those states, who come out and claim they have clients, they collect money for the services, they render the services, and they don't have any other work. And none of them went to school, they are not lawyers. So from where do they, I'm going to try to tell them that no, this is not a job, and we tell the clients, it's better you come and report by yourself. It will make more sense, because this is just like a third party making a report on behalf of someone. You don't have power of attorney, you don't have, there's no need for that. So, and that is what we have a proliferation of that in every state. So I want us to look at, so talking to the Nigerian Bar Association, I want to also see how we can drive, how we can think about sponsorship of bills in the legislature, because you understand the law very well. The issue of community policing is coming, state police is really coming up, and it's coming up very strong. And I am seeing a situation where state police will be passed as a law, as part of the constitutional amendment, and state police will come and will start practicing it, and will start having issues. And we'll be having issues because so many people who know better have refused to go and contribute. The Inspector General of Police has been proactive enough to make our own position felt. But state police is not just a policing system or policy that will affect the police institution alone. It's a policy that is going to affect everybody. It's going to affect the members of the public, it will affect the whole of society and all the communities. So everybody should make a contribution now, not when it has passed as law, then we start practicing it, then we start noticing the issues, or we notice that there are some gaps that someone will now start taking advantage of these gaps and will start complaining and advocating and having this. Then maybe I should talk about non-state actors. You see, the Edo State Security core network, or whatever it is, and just like all the others that are informed, they are like neighborhood systems that are operational everywhere. If well handled, it's a very beautiful concept. For now, in Edo State, I insist that they work with the police. So you are not supposed to find an Edo State security corps member working alone. They are not supposed to have a point of their own where they are not working with the police. And anytime they are working with the police will be mentoring them, and the police will be in charge. So in that case, we have the order now to work. It's okay for the police to do that. It's okay for this. So if we are going to transit to state police, we must know the difference between this neighborhood experience and the actual policing experience. Thank you very much, Mr. Chairman.
Thank you so much. I think it deserves a resounding applause. They are enlightening us, and I think the NPA should work closely with them. I think you should have a committee, police relations with the NPA, because he has told you now the advocacy should go beyond all these things. Scrutiny. You should scrutinize the profession. There's a scandal now from Uromi side. I was a judge there for about 4 years. It's just recently we discovered a lawyer who had been practicing there for more than 20 years was never closed with the bar. At the moment they detected, he had caught it, he took him there. He did cases before me. He won some, he lost some. But it had not been discovered, he never went to the law school. Some of you may be aware of that situation. So yes, that's what he's talking about. So the representative of the honorable speaker, your body appears to be the lifetime body. But you will also address the issue of the cuts, when it comes to the budget. You put in that in the House of Assembly. So I'd like to address it. You won't address anything at all. Even if your body is flat, there's a body there, there's pain. Yes, SSG has displayed his own parts. Maybe you tell us exactly what happened in the House of Assembly.
Hello. I want to start with all of this. The primary function of the House of Assembly, the only admonition I have for the MP in Iowa is that in the process of law making, there's always a section meant for public hearing. If there is no contribution from Lion Bar or people who are advanced in law, it's going to be the case of garbage. For laws to be very, very purposeful, there must be that collaboration. Then the major issue is on how the state will run. But the income does not concern the House of Assembly. That is meant for implementation from the executive. Lastly, sir, I will pray. All go to the executive. I would suggest that if he is not having the time, we can delegate on the executive officer to find out what and why has this happened. Then there will be proper understanding. Thank you, sir.
Thank you very much. Let's clap for him. I think we will restrict questions to just 4 because of time. I give them time. They have been very exhaustive, except they
there are some things that are still not clear, then the bar will supply by way of question or comments. Okay? Mr. Owo, let's start with you. Very brief, please. Very brief.
My intervention is with respect to the remark made by the distinguished Commissioner of Police Edo State on the proliferation of petitions by those who write to your office, writing on behalf of their clients even when they are not lawyers. I want to draw your attention particularly to how your predecessor in office, retired AIG Abutuyaru, is to ensure that the person is available to stand his trial. Thank you very much.
Thank you. Thank you very much. Mr.
Yes, Milo.
Yes.
Milo, the distinguished, respected senior advocate came in when the session was on. Kenny Mozia, senior advocate of Nigeria. Please, your hands together. Been with us from the 14th to Monday to Tuesday to Wednesday. It deserves a Sunday round, please. Can we appreciate the distinguished senior advocate? It's a welcome to the court, Madam Chairman. Thank you, sir.
Mr. Chairman, sir, my Lord, thanks for the privilege. My attention is also directed to the Honorable Commissioner of Police, Edo State Command. First of all, I want to commend you. You are a good man. You listen to us. You protect our interests. What you said here just now, you could have kept quiet. You could have decided to be approving those petitions. But what will bring food to our table is what you have just discussed. So we commend you. I recall that the first experience I had with you, I did a petition, it was not approved within a period. I called you. You are not known before. You said, are you around this thing? I said, yes. Come with the petition. I ended up spending about an hour with you. You are not known me before. You made a rundown of the activities of the police and areas that you are likely to improve. If a man is good, tell him he's good, then he will do more. Then, however, there are some very despicable practices of the officers and men. These are, I call them, too frequent roadblocks. Every pole is a roadblock. And the barricade, those stones, they are not reflecting. I almost had an accident 3 days ago along the second. They will put stones there. The tires, those are not reflecting. And then as they are going, they will leave them with impunity. As you are coming in the night, you can run into any of them. And I don't like some of the examples they show to this vigilante. Because those boys, you know how they are. They copy bad things easily or more frequently than the good ones. Please, sir. We know that you are full of agility. We know how you fight your battles. Please, help us. Go around secretly, disguise. Check these boys and officers. Some of them take bribe openly in the presence of vigilante. I didn't say all of them, some of them. So when you get there, you have the right, you have the power to discipline summarily as a CP. The one that is rank and file up to, I think, inspector level. But the other ones, you can recommend, you can send to IG, to the Police Service Commission to do. So most of these crimes or activities are done by the rank and files. They are more involved, sir. As we have started work, completely, sir. Thank you very much.
Thank you very much, Mr. Chairman.
First, my intervention is, let me first of all commend the Commissioner of Police for coming here personally. I want to commend you, Mr. Commissioner, for coming here personally. You could have sent one of your legal officers, somebody who is a lawyer, and is a lawyer to let them go and discuss by themselves. So thank you very much for coming, and I know that when you came, we were expecting some bullets. So I know you are not surprised because you have told us that you will survive. Mr. Commissioner, sir, first, on the issue of your achievement in the area of autism, you say you have the records. I commend you, I congratulate you, and I thank you for trying to make our city safe. However, sir, the law you referred to that was passed, clearly that law states that upon conviction on the issue of confiscating your house or demolishing your house, upon conviction. But we have instances where houses were demolished even before the cases got to court, even before those who were suspected, and in some cases who were just house owners, not directly involved in the offenses, their houses were demolished. We had cases where people were journeying homes in buses. The buses were stopped, they were raided, and the next day they were in court, even without the list of profiling. In as much as it is good to achieve these results, there is a danger if it is not done within the purview of what is permissible and allowable by law. Yes, you may have a very good intention. The danger is you are abusing the rights of individuals. And effort must be made, like I said. If the police are even taking time to do some profiling, you will find that you need not just bring all of them and pass the body to the courts, and then of course some of them would have suffered for nothing. I think for purposes of next time, we have passed that stage now. The police should be a bit more careful, because whether we like it or not, we cannot, in the pursuit of wanting to achieve results, sacrifice justice and sacrifice fundamental rights, sacrifice the rule of law on the altar of expediency. The next one I want to say, Mr. SSG, I also want to thank you for coming. You did a very good job defending what the executive has done. However, sir, first I want to say, I think somebody said, okay, that if the CJ said he wasn't going to go to the executive, that was not right. I think what my Lord said, the chair of session, was that the CJ said he was not ready to go cap in hand begging. Going cap in hand begging does not mean that he does not want to interface with the executive or the legislature. So I do agree that no chief judge should go cap in hand begging, because that is the intent of our constitution. Now, the reason why we find it a bit difficult and unable to fathom is because you have tried to say that it was based on the availability of funds. The funds that was available to Edo State government last year is more than the funds that is available to Edo State government this year, looking at the statistics. Now, if you now cut a budget that was like, if I'm not mistaken, about 2 billion, 6 billion, thank you for the figure, 6 billion, because it was already a state billion, to a mere 300 million. From 6 billion, not even 10%. 10% would have been maybe like 600 million. From 6 billion capital budget to 300 million. I do not need evidence to say that
something is fundamentally wrong, especially against the fact that the budget went up and not downwards. So, and by virtue of the way the judiciary is, because let me tell you, we are supposed to have separation of powers, even though you argue very brilliantly that that is not absolute. We all know that. But today, there is no legislature. It has been subsumed in the executive. And what we now have now is a legislature that controls and defers to the executive. Everything the executive wants goes through almost without serious deliberations. So, the last hope is the judiciary. We're not talking about a state. It is pervasive, where every executive governor wants to determine who the Speaker of the House of Assembly is, who the Deputy Speaker is, who even gets elected to the State House of Assembly. It's a problem. And unless we begin to address these issues, honestly, we are going to have a problem. Now the executive substantially has consumed the legislature. The next focus is the judiciary. And that will continue to shine, because once that happens, the country and democracy is gone. There is attempt. Whether we like it or not, it is not in the interest of the executive for the judiciary to have financial autonomy. They want to be able to control the judiciary. They want to be able to get judgments the way they want it. If we allow that, then it's taken. So we must tell them, I'm happy you are a lawyer. You know what is right, you know what we are talking about. It's not about now. It's about posterity, and it's about the future of our country. I thank you very much for this program.
Thank you. Let me give the last chance to Mr. Kasumi Esquire. Please, it's almost 4 o'clock.
Thank you, Mr. Chairman, for the session. Mr. Kasumi is the Secretary of the Bar. My own is directed to the CP. So we're sorry, it's an opportunity for us to meet with you and direct our complaint to you directly. My area of intervention, I wanted to intervene, although the IG is already intervening on the issue of subversion of investigation at the divisional level, area command level. What I mean is that you have a situation whereby a petition is written against the suspect, rather than reporting there, they jump to the state CID, or if it's at the state CID level, they jump to the area command without even reporting. And the AIG, the office of the AIG or the CP as it were, depending on the one that has the situation, takes up that investigation without recourse to the lower police command where the investigation, where the suspect was allegedly invited. That is now a very big commercial practice within the Edo State Police Command and the Zone 5. This is principally enabled by a practice we, on my own, as coined as petition racketeering. We have a situation where petitions are prepared and are taken, rather than taken to the CP's office, they are taken to heads of session. I do see the petition on the concert. That session will inscribe a code on it. What it means is that that petition, when it gets to the CP's office, must return to that session for investigation. That is the very beginning of corrupt investigation. I see that recently, I know recently you have stopped that practice. I saw a situation where certain petitions that can be investigated at the divisional police level, they wrote, I think a client of mine came to complain that they wrote to the CP and he took it to Owo. I said, yes, that's the way it's supposed to be. These are issues that can be investigated at the divisional police level, but because of the financial corruption, you know, the way a case will be investigated, in fact, it's already determined by the person reporting it, with the assistance of the head of session and the officers there. Please, we appeal that sanity should be brought to this. I'm happy the IG did it, that you cannot just jump from the AIG and it has brought a lot of sanity to the system. So that is my area of intervention.
just feedback from the CPU appear to have the heaviest body. Let me just respond to the lawyers. The SSG's body is light. It's a lawyer. The lawyers represent him very well. So just respond to the Muran.
Thank you. Thank you, my lord. The chairman. I will respond quickly. The first one I will talk about is about the demolition of well, I think that was not a question, it was more like a comment. So I passed that. Actually, it's a comment, isn't it? Yeah. Then about roadblocks, that's roadblock issue in the state. We've gone over it before. I got feedbacks from members of the community. As a matter of fact, before I started work here, I conducted a survey because coming to Edo State was my first time. I never came here for anything in my life. Coming here as the CP was my first time. So I conducted a survey to find out what their concerns were, what they wanted, how was the police serving them, how did they want to be served, and any suggestions about how they can do it better. And that was how I started. Then that strategy of roadblock, I also tried to get feedback, and I got a lot of feedback like the one you just gave me now. I don't operate without getting feedback to review. I heard many people complain of extortion, complain of the barricades, and I will tell you that despite the complaints, I continue with that strategy for a purpose. One, I have lost 6 policemen on the roads. You just stop a vehicle, the vehicle stops, it refuses to stop, and runs into the policeman, the policeman dies. And hit and run, the vehicle escapes. How do you get in? I come on the walkie-talkie, I tell all the people on the roads to stop the vehicle. Who is going to stand again and wait to be crushed by the vehicle? Do you think you can stop the vehicle if the vehicle does not want to stop? If there's no barricade? I mean, if you know how, let us share. See, so I discovered that I was dealing with people who were after the lives of my men. It is even understandable if you send a policeman to the road and the policeman encounters armed robbers or kidnappers and they escape bullets and the policeman dies. It's even understandable, you know. But one drunken child who manages to get money and say buys a GLK 90 million naira, you stop him after he has taken Mogadon or what they call it, and he refuses to stop on the road. And then, for God's sake, so I refuse. Even His Excellency has called me to order for this thing. I think that strategy has been very, very, very useful. Now, even when they were doing the Curtis killings, when you go shoot a man on the head, they say it's a Lexus car without registration number. I just called him in and say block. They just roll those stones on the road, and we are checking out. When they discover that if they hit, they can't escape, they either stop hitting or some of them will catch them. And that is how we'll be able to restore the city. You see, if you travel around the world, you will find places where they have recent crises. Like we went to United Nations mission. When you go to Kosovo, at the time there was still conflict, you will find roadblocks. When I was in Liberia, immediately after the conflict, you will find roadblocks. You will tell whether there is peace in a town by those kinds of things. In a place where guys, young men were killing and counting scores, 10, 20 in a day, and escaping without this thing. And in a place where a policeman stops a car, he doesn't stop, instead he runs down the policeman to death. I think that place is a place that deserves roadblock because there is no peace in that place. But somehow we've been able to restore peace. by this strategy. And so I appreciate your concerns, but I want you to also understand that, we didn't start this strategy from the beginning. We used it because it was necessary. Then the second, sorry, I said too much time on this. What the other issue? Okay, the issue of extortion, yes. Extortion, yes. We are trying to stop extortion. One, we have told the men that nobody should make returns to anybody. So if you have a reason, we have so many cases where we have brought reports that someone extorted money from someone and we investigated and made the person to return the money, and the defaulting police officer is tried and dismissed. We have so many cases. As I'm speaking now, we have more than 10 policemen in the cells for extortion. So they know it's a local area. But it has not stopped, I know, because the complaints are still coming, the extortion is still going on. But you will agree with me that it has reduced. Before now, there was a situation where the policemen operatives will come on the road without name tags, without any sticker on their cars. They pick someone on the road, they go round the town, then they go to POS and money is transferred. When did you hear about that last? It has reduced. Maybe it has not stopped. You see, so we are trying, we have not gotten there yet, we are still doing it, extortion is still going on, but we are working hard on it. And if you give us information about any extortion, we'll follow it to the end.
Thank you, CP. They gave you a suggestion. They said you should carry out sting operations. You yourself in Mufti, or some of your men in Mufti, they go out, let them extort from them, then you pick the policemen. Maybe if you try that one, if they know that people like you are out for sting operations, I think the extortion will cease completely. They suggested that.
Those that know my operation very well will not make that suggestion because they know that I'm on the road 247.
Okay.
They know, and nobody knows when I'm on.
Okay, that's
2 a.m., 3 a.m., they know. You see, not only in the city, Auchi, Irua, I'm all over the place.
Let's give a clip here. Don't worry, you understand yourself. Many looking at your gentility and at everyone else, they give you a clean bill. You don't look like the, I don't want to, you look like a police in the class, a special class. And I pray you keep it up.
Thank you, my Lord.
The learned professor will say a few words before the SSG.
Thank you very much, Mr. Chairman, sir. My Lord, I appreciate the way you have handled the session. Because when I came in, I was timed. So I decided to make the short use of my time. Hence, I could not tender the apology from the Vice Chancellor of the University of Benin. You know, most of us know that Professor Zoba Bright Murray, Senior Advocate of Nigeria, is an active barman. So today, he could not come and he sends his deep, heartfelt apology for not being there here personally. Because we just attended Professor Sadalo's commendation service. In fact, it was from the service I was down here. And he said, University Senate meeting today, shortly after that. So he now said, okay, let him go. The chairman of Senate said we should go, then I will come here, and I'm intending the apology. He's sorry that he couldn't come here personally.
You don't need to understand that. You stood, if you tell him that the presiding chairman said that you discharge yourself and couldn't be, that you will not be here, you will do very, very well. I don't like that, you will do very, very well. Thank you. The SSG will come it up. You have tried SSG. We also commend your efforts. And the bar welcomes you with
we welcome you with all our hands. But just round it up. As I said, I want to give it to you properly. Take the message home. That's the point.
Yeah.
Take the message home to His Excellency. This represents a force. What you are seeing here is a major force. And by the grace of God, we will succeed in the state. But take the message home that this is the feelers got from this meeting today. They came to represent the development, and this is the feeling. Take it home to him. I think they will adjust everything. So what's let us? It's a stakeholder here. That's why we are here.
Thank you.
Yes.
Thank you very much, my Lord. I have listened to the comments and the concerns expressed, and I want to say they are very valid. They are comments or issues that should really bother all of us. As we say, ministers in the temple of justice, we need to continue to uphold these fundamental rules of separation of powers, independence of the judiciary, as well as the rule of law. Of course, everyone is also very concerned about what we are beginning to see increasingly, not just in Edo State, in Nigeria and other parts of the world, where we are gradually gravitating towards the rule by law, not the rule of law. You know, where power weaponizes the law and the institutions to advance its own cause. So that is a big problem. And that is where the vigilance of the bar should come in. The Lion Bar will do a lot of advocacy, a lot of interaction to see that we continue to be the defenders and the promoters of justice. On the relationship management between the judiciary and the executive, we'll continue to improve that. I must say that yes, things are better from where it was as at the time these incidents occurred. And truly, there was a meeting between the CJ and His Excellency on this matter where things were explained. And that meeting has continued to take place. On my own part, I have also played a sort of mediatory and interfacing role between both parties, and we are looking at how to smoothing that relationship and also smoothing whatever rough edges might be there. I think there's room for improvement and continue to work at it. Thank you very much.
Thank you so much. So we are going
Thank you, my Lord, the Chair of Session. My Lord, we have the Planning Committee Chairman. He has had a very great week. Maybe appropriate young man to deliver the vote of thanks. Our thought, Samuel Esper. Please, the Planning Committee Chairman. And particularly strategically because of the turnout you have had, you have done a good, nice job. Please, your hands together for this young man for a great job.
Thank you so much, Mr. Esper. Permit me to stand on the already established protocol. To the Chairman of Session, Honorable Justice B.A. Ahiero, the late Speaker, Professor Edoba Bright, Omori S. Ably represented by Professor Nelson Ojukwu Ogba, the SSG Umar Musa Ihilo Esquire, the Speaker of the Edo State House Assembly, the Right Honorable Blessing Agbebaku, ably represented by Mr. J. Oyafi Esquire, the Commissioner of Police, Edo State Police Command, CP Monbe and Monica. We appreciate you for finding time to be with us in this session. Say the Lord will bless you richly in Jesus' name. I remember how I disturbed most of you with several phone calls and text messages, and I am glad that you were able to make it to this session today. And you have blessed us with such an enriching session. We are very grateful, sir. Thank you very much. And indeed to all members of our branch. Let me start from the Silk, Mr. Kegi Mosia. From the inception of this law, you have been with us. We cannot thank you enough for all that you have for us. You are one we regard as our father. We are grateful, sir, for finding time to be with us. We also thank their lordships, ably led by the Honorable CJ of the Edo State Judiciary, the Honorable Chief Judge of Edo State, Honorable Justice D.I. Kumbowa. We are grateful for all that you have done for us, even this law week, and your brother judges. We're grateful for the presence, the attention, and even the use of this magnificent hall for this law week. We are grateful. And indeed, so all members of the Lion Bar who did not leave us alone, they have been in this session, in this hall, since we began even with the CJ's cocktail on Sunday. We thank you very much for not abandoning us, because after the planning of the law week, we could have come to this hall and meet empty seats. We are grateful, sir, for the opportunity. To the media committee, led by Mr. Samuel McKelly, we are grateful for the magnificent work that you have done during the sessions of this lobby. All members of the press who are with us, media committee, the sound, and everyone, we are grateful. Not forgetting that even as the sessions are ending today, we still have the football match tomorrow, the novelty match between the NBA Benin branch and the Fufu branch. And on Friday, please, on Friday, we have a gala night at the bar house. We're still inviting every member of the Lion Bar and indeed every member of the judiciary to please grace that occasion with us. We are grateful. Thank you, and God bless you.
Thank you very much, Sam Matoy. And thank you very much for putting together Law Week 2026. Please, we crave the indulgence of everyone. Please be seated for lunch. Get out your lunch tickets. They will hand you the food on your seat. Please, everyone, remain seated. Thank you very much.
All right, distinguished ladies and gentlemen, we now have the photo session with my Lord, the chairman of the Judicial Session, and very distinguished members of the panel, and the chairman of the bar, the members of the executive committee of the NBA branch.
You can capture all, right?
May I also remind us that tomorrow Thursday we have a valedictory service in honor of Professor Faith Osadolo right here at the ceremonial hall of the High Court at the time will be 10 a.m. in the morning. Please let's be here to honor our fellow colleague. Please let's not forget that the law week shall be rounded off with a gala night on Friday by 5 p.m. at the FBA Secretariat. Thank you. Distinguished colleagues, while we are having a meal, let's not forget that tonight we'll also be having a nice evening of merriment at the bar house, and tonight is a sit-out with the NBA chairman, which promises to be a fantastic and very, very refreshing evening. Please let's all be at the Friendship Center. While tomorrow by 2:30 p.m. we'll be having the Chairman's Cup at the Samuel Memorial Stadium. After which we all reconvert at the bar house for more memories. very much. Okori.
This is the media team. Slow team.